great state of Ohio and this honorable court. You may be seated.
Good morning. Welcome to Lawrence County Municipal Court. Today is November 27th. We have a very large docket today, as you can look around. The courtroom is packed. We'll get to your case as soon as we can. We have reviews first. People with reviews are going to be called. If you're in that group, when your name's called, come up to the table to your right and stand there. I'm going to go over your file with you. Call the reviews, please.
James G. Adams, Destiny Anderson, Timothy Clark, Aaron Cron, Norvin Dale, Donald Dickus, Kenny Ingalls, and Travis Jeffers.
James Adams. James Adams. James Adams is case number 23765. He's done a little bit on his case, but not much, and he hasn't appeared.
You come in and have a seat.
There'll be a warrant issued for failure to appear. Destiny Anderson. Destiny Anderson, you're here? Okay. So, 222665, you're at Mahajan. I had a report from them in October. Is there anyone from Mahajan here today?
I gave the probation my completion letter and all of my drug screens
Okay, this morning, or when did you do that?
last week.
Okay.
I'll look on it, maybe on my desk.
I got paid this morning to pay off my fine, but
Okay, how much are you gonna pay on the fine?
I think I owe $657.
$675 is what?
$675.
You're gonna pay the whole thing?
I
Okay,
have to go cash my check.
you've got 5 days of community service to do too. So when are you gonna get that done?
I have to get a new paper. I've done, I think I have 1 day left, but I need a paper.
Now, Roach?
Yes. Okay. Okay, get a certificate of completion from Mahajan. And it looks like these are urine screens attached also.
Yes.
Okay, so it looks like if you pay this off, the only thing you'll have left is your community service to do. So, good job getting that finished. Okay, and you're working, right? Where do you work?
I work through Wise Medical, and then I also pick up Edgewood Nurse System.
I'll set your next hearing for, I'll give you a couple months. So January 26th of next year at 9 o'clock, you should get your community service done by then. If you do, you don't have to come back. Any questions? Okay, that's all. Just confirm with Mr. Major that you got your hours in.
Okay.
Timothy Clark,
Do Your Honor.
2373. Okay, you've done some community service since your last hearing, and you made a payment today on your case, and you completed the driver intervention program. I'll set you in January. Also, you don't have that. I'm showing 1 day of community service left and some time. Okay.
Yeah, this is 1 day, Your Honor.
Okay, I'll set you for January 26th also. If you get it finished by then, you don't have to come to that hearing. 9 o'clock, January 26th.
Yes, Your Honor. Thank you.
Aaron Cron, 19288. Aaron Cron, not here. Finished his community service, but hasn't paid all his fines and costs, so there's going to be a bench warrant for failure to appear. Norvin Dale.
Yeah, here, Your Honor.
This is, you just have fines and court costs to pay.
Yeah, I got 100 for today.
Okay.
I'll have the rest of it paid Wednesday when I get paid. Well, next Wednesday when I get paid.
All right, see the clerk. Okay, see the clerk to make your payment.
Okay.
And this is a newer case, so I'll set you in January also. January the 19th, if you pay it off by then, you don't have to come back for the next hearing. 9 o'clock, January 19th.
Thank you, Your Honor.
See the clerk to your right, make your payment. Donald Dickus, 23-104-105. Donald Dickus?
Yes, sir.
Yes. Okay, Bethesda is saying that they don't think they can help him anymore. This is my read of it, and that he should be going to mental health counsel rather than to substance use.
I've agreed to go with Manu.
Anu.
Okay,
There.
all right, has that already been started, or?
Yes.
Okay. Well, I need a report from them. And you still have some fines left to pay.
I do. It should be paid off, sir.
Let me check on 19,847. Can you check that and see if it's paid?
Yeah, I thought I had them paid now.
And 21,3173.
That's what I was
I
told.
don't know if you can show just all, if there's a balance for that. Oh, well, one reason may be I've got some files that aren't yours, so
Okay. we
looks like
have
his is paid.
Zero balance on 23-105.
Okay, that's the only one I've got left. So those were,
Okay, and then I have
those others were not his files, so.
23-104 is, which I get.
It's also clear. Okay, you are right. You paid all your fines, so. Okay, let's try this anew counseling and see how that works. I'm concerned about your alcohol consumption.
I have slowed down way considerably, sir.
Okay, well, that's good. I'll set your next hearing. Let me see what the calendar looks like. I'm going to make it December 26th, the day after Christmas. December 26th will be about a month out. Be your next hearing, 9 o'clock.
Thank you, Your Honor.
Try to get me a report from Anu by then.
Will do.
Thank you. All right, Kenny Ingalls
Yes, sir.
is here, 19,847. Okay, this is one. Can you make any payment on your case today, Mr. Ingalls?
I did, I only paid $20, Your Honor, but I don't have any income, and you know I just got out of prison the 3rd of October. Yes, sir.
All right, I see.
I just got out October 3rd, and I still don't have my check or anything, so
It is in the file.
I would hope that maybe you could put it off till January for next time, and maybe I'll have some of my own money I can pay more significant.
I'll make it close. December 29th will be your next hearing. 9 o'clock, December 29th. Travis Jeffers, 23-239. Mr. Jeffers is here. Looks like you've done your community service, paid your fines. The only thing I don't show, your entry said you were going to go to treatment in lieu of going to the driver intervention program?
Yeah, I
Have
went
you done
to,
that?
I have a report, Your Honor.
Okay. Okay, are you going to continue at OVP, or what's the,
they said they didn't need me back anymore after.
well, it's kind of a mixed message. I don't know, is there anybody here from OVP?
I went probably the last month and a half there.
Because I mean, I'm looking at the letter, they say they got, and she probably needs to hear this. Want to get Mrs. Min in the courtroom?
Yes, sir. I believe they faxed stuff over here also that I may not have.
Your Honor, I don't know where she's went, I can't locate her.
Okay.
Yeah, she spoke with me.
Okay. Mr. Hawthorne's advising her she's coming.
Okay. Thank you. All right, Mr. Mint, I need some clarification on this gentleman. His name is Travis Jeffers. So I've got a report dated November 21st, authored by David Clay. And it says that his assessment, Mr. Jeffers, was diagnosed with alcohol use disorder, moderate severity. And then goes on to say, he believes the circumstance leading to being seen was incidental. He does not have any ongoing issues with alcohol use. So, I mean, to me, that's inconsistent to say he's got a moderately severe alcohol use disorder than to say he really doesn't need any further treatment. And in his history, I mean, this was a second offense OVI within, we had one in 2015, had one 2023. So to me, that indicates, because we know that people, when they get an OVI, they don't get an OVI every time they go out and drink and drive.
Right.
It's very rare that people get caught, actually. So I think this, can you meet with him and let's get a little further signal? Because I think he's believing he doesn't have to do any further treatment.
It sounds like they diagnosed him with alcohol use disorder, but then he felt that he didn't need the services, so they're not going to continue them if he isn't willing to do that, basically. So, but I
Okay.
will meet with him and figure it out.
Well, here's what's going to happen then. If you're not going to continue with OVP, then I'm going to make you go to the driver intervention program.
I don't care to continue, that's not the issue.
Well, my goal is that you change your behavior so this never happens again. I don't want, I don't want you back in court. I don't want you out on the highway being a risk to yourself or other people. That's what I want to see happen, is that there's a change here. And I'm not sure I'm seeing evidence that there's going to be a change. Admitting that there needs to be a change is the first step in changing. You say, well, I don't really have a problem. Well, you've had 2 OVIs. That probably puts you in the top 2%. Probably only 2% of people get 2 OVIs. So that's a problem. So you need to recognize that, admit it, and then change some of your behavior. So you're going to continue at OVP. I want you to talk to Mr. Min about that, and then I'll set you for another hearing, and I'll make it a couple months out since you've done everything else but complete your treatment. So let's make it January 29th at 9 a.m.
Thank you, Your Honor.
You're welcome.
Bradford Lusher, Stephanie Plumley, Cody Mead, Stephen Lynch, James McClellan, Naomi Mullins, Jacob Williams, Williams, and Austin Wise.
Bradford Luster.
Yes, sir.
213173. All right, Mr. Lusher has paid most of his fine. I'm still showing a small balance. Can you pay anything today, sir?
Not today, but at least by Friday, I'm trying to. I got some trees to cut. I'm starting tomorrow, and hopefully I'll get you something by Friday.
Okay, I'm showing also you've got 5 days of community service to do,
Yes, Your Honor.
and that needs to happen. When can you do some community service? Get me a commitment.
I actually showed up Saturday, but nobody was here.
Well, all-day weekend.
Yes, sir, I understand. I was actually thinking about just getting a room at the hotel up the street and maybe trying to wipe everything out on maybe next week.
Okay.
I just got to get these trees out of the way to cut, and then I got to sell the...
Where are you living now?
I'm staying at my dad's in the, I got a camper out behind my dad's house.
Where's that?
It's, you know where Hughes Branch Road is, going towards Beach Fork Campground?
Oh, I know where Beach Fork is.
Well, just as you start going up the hill, he lives right down there the hill, got all them antique cars for sale.
Is that where you're from originally?
Originally I'm from Altizer in Huntington,
Okay.
yes, sir.
At the time, it looks like you had a Piketon, Ohio address.
Yes, sir, yes, at the time.
You're
And
not living there now.
I'm still welcome there. Most of my I've got 4 vehicles up there still, and I've got a job for RKJ waiting on me. I didn't want to go and then leave this not, wrapped up.
Yeah,
It's just, the problem is,
let's get it done in the next time frame, get your community service done.
all righty, I just haven't got my license back. It's the only thing that's got me stalled. Everything I do, I got to do with no license or get a ride. And
That makes it hard.
Yes, sir, it does. It's a lesson learned, that's for sure.
All right, January 22nd is going to be your next hearing. If you get your community service done, you don't have to show up.
All
9
right.
o'clock, January 22nd.
At 9 o'clock?
Yes, sir. Stephanie Plumley.
Thank you, Your Honor.
You're welcome. Stephanie Plumley. Stephanie Plumley's been called for, has not appeared. Okay, she did call in and tell the clerk her car was broken down. So I'll set her file aside and we'll recall it later in the docket. She said she was still trying to get here. Cody Mead. Cody Mead. 23-152, 22-4690. Is not here, has things left to do. So there'll be a warrant issued for failure to appear. Stephen Lynch.
Yes, sir.
Case number 18502. You just have to pay off your fines and court costs.
Yeah, Your Honor, last time you told me I could work, I guess
Yeah.
you said I could work off a few days. I'm gonna pay 15 today, and then I'm also doing community for common plea, so, and with no license like the last gentleman, it's hard to get around, to be honest with you, but
All right, see the clerk, make your payment, you can work, where do you live?
Chesapeake, the village.
Okay, well, it'll be easier for you to get here than anyplace else.
Right.
You can come here to do your community service any day at 7:30, Monday through Saturday. And you can't come on holidays either.
Thank you, Your Honor.
So I'll set January 5th as your next hearing,
Thank you, Your Honor.
9 o'clock. See the clerk, you're making a payment.
Yes, Your Honor.
James McClellan.
Yes, sir.
It's case number 21682, 181168, 163521. Okay, it's a good report from Restoring Hope Recovery Care. You have some community service left to do.
How many hours do I have left?
I'm showing 48 hours.
All right.
Where do you live, sir?
I'm in Franklin Furnace right now.
Okay. Well, you can do it at Arraignments Municipal Court. That's
About to
closer for
ask
you than coming here,
That'd
right?
be cool, yeah.
So they have a
Definitely
community
a lot
service
closer.
program there. Just tell them it's for this court and have them send the hours up here and we'll
All
give you
right.
credit for it.
All right, thanks.
Can you pay anything on your fines today?
I don't have a job right now, so no.
Okay, we'll start doing community service. You can even work off your fine
All right,
once you've
sounds
done
good.
your court-ordered community service.
All right.
December 26th is going to be your next hearing. These are older cases, that's why I'm setting it soon.
right.
December 26th, 9 o'clock.
Thank you, sir.
Good job
Thanks.
on your treatment.
All right,
Keep it up.
thanks.
Jacob Williams,
Yes, sir.
22-806 and 807 at RS. Okay, it's a very good report, very positive.
Thank you, sir.
Your fines are paid, you gotta finish your community service, and you did some since the last hearing, it looks like. All right, January 5th will be your next hearing also. 9 o'clock. Keep working on your counseling.
Yes, sir. I appreciate
Sounds like
it.
that's going well.
That's going great.
Yeah, I've been trying to change.
Good.
Thank you. I
Good job.
appreciate it.
Austin Wise. Mr. Wise just owes $50 and he has to, okay, he did complete the dip school, so that's done. Okay, I'm going to pass this. Let's put this on my desk. I'm going to review it, see if there's, because that's not much for him to be short on before I issue a warrant, so. Naomi Mullins, 18/12/14. She finished her community service. She hasn't paid her fine. She didn't make a payment today, though. Maybe it just came in off the internet. $8 payment today. Naomi Mullins here.
Is it Mamie?
It's Mamie.
I'm sorry, Mamie Mullins. Sorry. All right, you did make a payment today. That's all you got left to do is pay this off.
I have community service set up next week to work some of it off.
Okay, yeah, we'll give you credit for $50 a day, whatever you do. I'll set you for January 5th also. 9 o'clock, January 5th.
Thank you.
You're welcome. Okay, we're going to start the arraignments now. Good morning, Mr. Morford.
Good morning. Arraignments, this public appearance, in court, in the courtroom now.
So if you have a new charge, or if you had an old case where you missed a hearing,
Have a seat.
or if you want a warrant withdrawn where you did something on an old case, if you,
Ma'am, have a seat. Have a seat.
yeah, don't leave until, let me make instructions before you leave, and then you can leave if you want. If you think your case is set today and you didn't get called for review, go check in with the clerk, because it wouldn't be on the docket day if you missed a hearing previously. When your name is called, come up to the table to your right. I'll go over the charges with you. You have a right to remain silent. You don't have to say anything. If you choose to make statements, though, it's all going down on the record. It can be used against you if you get up and admit something about your case. That prosecutor can use that to prove your case against you. You have a right to have an attorney, to have one appointed if you can't afford one and are facing a jailable offense, which most of the cases here are jailable. You have a right to bail, to make the state prove any charge against you beyond a reasonable doubt. Those are your rights. If you enter a guilty plea or a no contest plea, you're waiving those rights. You should not do that. If you're not sure what's happening, if you're confused, if you don't know what to do, if you want to talk to a lawyer, if you want a trial on your case, any of those reasons, you need to enter a not guilty plea. Not guilty is the safest plea you can enter. Call the first case.
State of Ohio versus Gary Dale, case number CRB 23323 A and B.
Gary Dale, this is for arraignment.
Your Honor, we had, Mr. Dale had failed to appear for court. I think there was some miscommunication.
November 6th, yes.
Yeah. Part of his case was dismissed, part of it was not. The DV was dismissed, but the obstruction wasn't. And Mr. Dale was pulled over, I think, this past few days. He was released from jail. I just asked that this be reset for another pre-trial for us to figure out the obstruction charge and that he'd be allowed to sign his own bond on that.
All right, I'll up the bond to a $2,000 signature bond.
Sign right there, Gary.
So you'll need to sign a new bond. And what's a good date for you to come back? Let me give you what dates the court's looking at.
Yeah, you're good, you're good. They'll fill out the rest.
The 18th of December, 26th of December, 29th of December.
The 26th would be
Okay.
fine.
All right, December 26th will be the pretrial for Mr. Dale at 10 o'clock.
Great, you're good.
Thanks.
State of Ohio versus Dean Fields, case number CRB 23656. Dean Fields. Did not check in, you know.
Dean Fields. Okay, he was served with a copy of summons on November 2nd to appear today. Has not appeared, so there's going to be a warrant issued for failure to appear.
State of Ohio versus Carl Carpenter Jr., case number CRB 19231. Carl Carpenter Jr. Did not check in. But apparently did.
All right, sir, are you Carl Carpenter Jr.?
Yes, sir.
It's alleged, Mr. Carpenter, that you failed to appear for a review hearing October 4th of 2019 and had a warrant outstanding since then. Do you understand that allegation?
Yes, sir.
Do you admit or deny it that you failed to appear?
I admit it.
Do you have an explanation for not appearing?
No, sir.
Did you just come in on your own, or did you get arrested on this
I
warrant?
came in on my own.
Okay, so you knew the warrant was out there?
Yes, sir.
Are you still living in County Road 31, Chesapeake?
Yes, sir.
I'm showing you have 5 days community service and fines and court costs to do.
I'll check on that. That's the first I've heard of that.
Well, that was the judgment entry from April 15th of 2019. You were found guilty of a theft offense from Walmart, had a $100 fine, court costs, 10 days in jail suspended on the conditions you do 5 days community service.
That's the first I heard of that, but I'll do it.
Well, let me ask you this, do you admit this was you, or did somebody steal your identity, or what happened here?
I was with somebody at Walmart, stole something, and got arrested for that, yes, sir.
Okay, I mean, were you in court on April 15th of 2019 and pled guilty to this charge?
I don't think so. I think it's the first time I've heard of it, because I forgot about it.
Okay. Well, I'm going to enter a not guilty plea for you then as to the warrant. Do you have a job?
No, sir.
You don't have any income at all?
No, sir.
And looks like whoever the person was that appeared did not have counsel. So I'm going to appoint Mr. Smith to represent you.
Yes, sir.
So, Mr. Smith,
Yes, sir.
it's alleged from the file that there was a plea entered, but it's rare, but I have had people's identities stolen before, and someone else entered a plea to them and they didn't actually appear.
Sure.
So he's saying he has no memory of this, so that's going to be the issue. I'll appoint you to represent him.
Yes, sir.
He did come in on his own, so I'm going to let him sign a $1,000 signature bond.
Thank you, Judge.
So there'll be a pretrial on the review. And I'm looking at the 18th, 26th, or 29th of December or into January.
18 is probably one up in January, Judge, unless we did it next Monday, but that's probably too soon.
We could actually do it next Monday, the 4th.
I'm here the 4th and 8th, either Monday or Friday next
Let's
week.
do it the 4th.
Okay, we can do
It's
that.
an old case, so let's get it moving. December 4th, pretrial at 10 o'clock.
December 4th, week from today.
State of Ohio versus Amanda Hicks, case number TRD 12-1804, CRB 12-456, CRB 08-162.
Thanks, sir.
Amanda Hicks, this is failure to appear for a review hearing on November 17th, so 10 days ago.
Yeah, I thought today was my court hearing. I apologize.
And all you have is fines to pay. Do you have a payment on your fine today?
Yeah,
How much are you paying?
40.
All right, I'll withdraw the warrant since you came in on your own.
Okay.
So we cancel the warrant, go to the clerk's office, make a payment, and I'll set you, this is an older case, so I'm going to set it for December 26th,
Okay, thank you.
9 o'clock, day after Christmas.
Okay.
See the clerk before you leave.
State of Ohio versus Kimberly Gannon, case number TRC 21-3329, A and B.
Okay, this was set for a review hearing on November 13th. And looks like you weren't here then?
Yes, Your Honor. I thought it was today.
Okay. Are you still at Bethesda?
Yes.
Can we get a report?
Yes, Your Honor.
And I'm concerned about the screens that I see, so if you can focus on that. I want you to go talk to the representative from Bethesda, and then we'll have you back. She's going to get a report. Since you weren't here on the 13th, I don't have a report for today, so I'll have you back up when we get a report.
State State of Ohio versus Elijah Roberts, case number TRC 23-1772, A, B, and C.
Sir, are you Elijah B. Roberts?
Yes, Your Honor.
Mr. Roberts, it's alleged that on November 21st at 10:56 p.m. in Windsor Township, you were driving a vehicle while being under the influence of alcohol, drugs, or some combination of those things. It's alleged this would be your first offense. On a first offense, the maximum you face is 6 months in jail, a $1,075 fine, and a 3-year license suspension. That's the most the court can impose if you're found guilty. There is a minimum. Most charges don't have a minimum. This has a minimum. I can't go below. If you're found guilty, you have to receive at least 3 days in a treatment program, $375 fine, and a 6-month license suspension. You understand the possible penalties on that charge?
Yes, Your Honor.
And there's 2 other charges. Failure to wear a safety belt, that's a mandatory $30 fine if you're found guilty. And failure to control your vehicle, that's a minor misdemeanor. There's no jail time on it. Maximum penalty is $150 fine. So you've got those 3 charges. Do you understand them?
Yes, Your Honor.
I explained rights earlier. Were you here for that?
Yes.
Do you understand your rights, or you want me to go over anything about your rights?
No, Your Honor.
How do you wish to plead to these charges?
Not guilty.
Do you want a lawyer appointed to represent you?
No, Your Honor, I will, I guess.
Going to hire your own?
Yes.
How much time do you need to do that?
I don't know.
About a month is about the longest.
That would be fine.
Longest possible time?
Well, yeah, a month would be great.
Okay, I'll set it for a pretrial on December 26th. That's going to be a Tuesday. Usually court here is on Mondays and Fridays, but Christmas is on Monday this year, so court will be closed on that Monday. We'll have court on the next day, Tuesday, December 26th. It'll be a pretrial. So you'll be here with your lawyer at 10 o'clock on December 26th, unless your lawyer may tell you, well, I've made arrangements for a different date. Then you come the date the lawyer tells you to be here. I'm going to let you sign a signature bond of $1,000. What that means is you're going to sign a piece of paper that says, I promise to come to court as ordered. If I don't show up, I get a $1,000 penalty and a warrant. So if you come to court, you don't have to post any money. Any questions, sir?
No, Your Honor.
Okay, that's all.
State of Ohio versus Kyle L. Akers, case number TRC 22-25-27 A and B, CRA 23-378.
He's in, oh, that's right, we brought the prisoner, yeah.
We're going to have a trial, so they just brought them all.
Okay. Your Honor, Mr. Akers was scheduled for February because he's been in the Greenup Boyd County Jail. Mr. Sowards was aware of this. The last hearing we had, Mr. Sowards was here. Mr. Sowards knew where he was. And I just asked that you reinstate his bond and allow him to set up another hearing.
Yeah, but I didn't have my dad call since that happened.
So yes, Your Honor, we just asked to be set for another pre-trial, allow him to sign his bond.
Has because when he was here last summer, there was a warrant then outstanding from Meigs County, Ohio. Has that been resolved, or is that still pending?
He gave me a phone to turn myself in, that's what I was doing. No, I still need to go turn myself in, but maybe a grand that again, that's what I was going to do.
Well, the problem is, he had a chance to go turn himself in before, and he didn't do it.
No, that's what, That's what I was doing, so you let me out of here, and I had that drug court over in Kentucky. I went over and let them know I was going to turn myself in, and they walked me up to Florida Rivers that day.
Yeah, Your Honor, Mr. Sowers was here that day, and also understands the situation. He had warrants out of two different places. What I would have went out of Reno, he would have checked up in over at Reno.
Well, we had to have a warrant over at drug court.
Yeah, drug court, over the drug court to check in, they kept him.
Yes.
He finished that. And
I did serve out on that.
Okay. Now he's back over here, but he didn't have the opportunity to go to Mexico.
And I was going to turn myself in, and they walked me up to a further notice when I told them I said, turn myself in, so, which I was still doing for you, the opportunity.
What's the state's position on this?
Well, we've got a 2022 OBI that's still pending. And
It's a second offense.
Now,
And he's got some sort of warrant out of Meigs County. Let's see if I can tell what that's about, which he's never appeared there on.
Says here, he was supposed to turn himself in before
It's a-
6/30/23.
Some sort of felony. Can't really tell. It's from, I've got a fax from the Meigs County Sheriff's Office. It gives me the case number, but it doesn't really tell me what type of charge it is. But it was issued by the Common Police Court, which tells me it probably is a felony.
so we don't know whether at this point there's still,
No, he says he's never appeared there.
I was going to,
He was in a drug court in Boyd County, went over there, I think explained what happened, and they locked him up.
but I served out over there, and I was still able to turn myself in and give me the officer.
He has a bond up. He posted a bond with Mr. Sowers, so I don't know if Mr. Sowers, of course, if he wants to be released off the bond, what the status of that is.
Well, Your Honor, Mr. Sowers stood up in the last hearing we had, Mr. Akers, and he was well aware of this. That's why we scheduled, you'll see this scheduled out to February. You see there's a bond forfeiture hearing in February.
March 1st, actually.
Oh, I'm sorry, March 1st. But that's the reason we scheduled that bond forfeiture hearing out so far, because we knew it was going to be released.
I'm going to send him a copy of the bond and see if we can get a response as to what he wants to do.
and we know how many days Mr. Akers has been in jail now here.
From here, I got extradited over here Saturday.
I'm just going to tell him we need your input on this.
You want to recall it?
Yes. And probably wouldn't hurt if we got some input from Meigs County too. I mean, if he's wanted for murder, that's one thing. If he's wanted for some kind of probation violation, that's another. So I'd really like to know what the basis of the charges are in Meigs County.
We'll try to find that. And from our perspective, Your Honor, our recommendation is going to be based on some way to resolve this charge for it's been here for a year and a half.
This case will be recalled later in the docket.
State of Ohio versus Ethan R. Anderson, case number CRB 2319.
So, Your Honor, Mr. Anderson has, this case, he also is being held on common plea order.
He was, is Megan still here? He was with QRT as of last summer.
Your Honor, he was discharged from
Okay.
QRT some time ago.
For non-compliance, I take it, or?
Yes, he came to my office, told me that he signed up with services from hometown and it was all a lie. And then I was never able to reach him again after that.
Your Honor, I think we should just reset this and see how the common pleas deals with him, and then we'll follow the lead on.
So he's has a holder from common pleas also, so he's not getting out regardless. Do you have a date to go back to common pleas?
I don't believe so. You were just, probably just the rest of the weekend, so, he should have a date soon. Mr. Smith is his attorney.
Oh, okay, let's get him in. He has some input on this. The case here has never been resolved. It's been pending. Domestic violence. We have Mr. Smith in the courtroom, please.
Approach, Your Honor.
Yes.
This is in that last case. There's another file that has the exposition in it, and it says that.
Oh, okay.
This is the judgment entry.
Okay. All right, thank you. All right, Mr. Smith, I think this is Mr. Anderson?
Yes.
Mr. Anderson is your client in common police court?
He is, Judge.
He has a case here that Mr. Stratton's representing him on that's still unresolved. It's my understanding there's a holder out of common pleas, probably on a warrant.
I would imagine, I just found out today he's in jail. I didn't know he'd been picked up till this morning. So I can confirm that, but I would think there should be.
And then you have no idea as to when it'll be called before the common pleas?
I do not, Judge.
Probably won't be this Wednesday, I'm guessing.
I wouldn't think so. I mean, I'll be there, but I've got, let me double check. I've not got an email or something from the common pleas, but I don't think it would be this Wednesday.
Most likely it will be the 6th.
Yes, sir. That'd be my guess.
So set it here for the 8th.
That'd be, yeah, they'd find as far as if Mr. Stratton's available.
All right.
All right, December the 8th. What kind of case is it there?
It is a pending arson case, which I understand is going to be dismissed, and there's an F5 possession case as well.
Okay.
But I think the arson case is going to go away. But that F5 is still hanging out.
He had been ordered here to treatment before, and he was...
Yeah.
So what I'm going to do, I'll lift the warrant so that if common police wants to send him to treatment, whatever, my holder's not going to stop him from doing that.
That would be appreciated, Judge, yes.
All right. He has to be here, though, December the 8th at 10 o'clock for a pretrial.
State of Ohio recalls Kyle Akers, case number CRA 23378, PRC 222526.
Did you get a message on Mr. Science? They got the one
He said he's not in the office. He doesn't have the file with him.
Your Honor, we found out it was an F5 out of Mixon County. He's actually been in contact with the Alabama, I know for a fact, twice he's been incarcerated and waiting in court. I just asked that you reinstate your file here, allow him to turn something today, which he will do, you know, in the court hearing. We'll make sure you keep track of that.
Okay. I'm texting with Mr. Sowers right now. So it's actually, let's see if I can get a response right away.
Your Honor, I've got an alternative.
Enter a plea.
Well, yeah, we've had it over years. If he pled guilty, we would ask to delay sentencing. We'd have no opposition to him being released and go to the next county and come back for sentencing. At that time, I think we want to assess if he has ongoing substance abuse issues that might need to be addressed through some more counseling. This is a second offense.
Well, I think the big issue is, does Mr. Sowards want to stay on the bond or not? Does he feel like he should be released? If he stays on the bond, then I'm more comfortable letting him go to Meigs County. If we don't have a bond up and he decides to skip out, it's going to be hard to get him back. Yeah, let's recall it. I don't have a response yet.
State of Ohio versus Corey Little. Case number CRB 23-194 A and B, CRB 23-195, CRB 22-491.
All right, this is Mr. Steyer's case. I think Mr. Holt was on some things too, wasn't he?
Your Honor, I've taken up Mr. Holt on this.
Okay.
Little retained me on some, but I was avoided later on others. The state has, Mr. Little has felony charges pending in common pleas court that are ongoing. If he's convicted on those, a prison sentence is fairly likely due to the nature of the charges, the milder cut. In light of that, Mr. Hill was offered and Mr. Little was agreeable to recommendations in exchange for a guilty plea on these charges, that the state would recommend 30 days in jail, credit for time served, and basically put the case in by jail time, which if the court would approve that, we'd be willing to do that today.
So there was, that charge is still pending?
That charge is pending at this time, yes.
Is that destruction, some sort of destruction of property type charge?
It's a tamper with evidence and a vandalism are what are related to the ankle undercut, and then I believe there's a possession charge as well. The possession charge isn't something we necessarily carry with prison time, but the ankle undercuts tend to result in a 3-year prison sentence, if convicted.
Mr. Hill?
Well, that's our recommendation, given the totality of the circumstances. And he would be pleading to several of these violation of the protection order. And so that if he did it again, obviously we have another felony.
And that's what you want to do then?
Yes, we'll do that.
Is that correct, Mr. Little? Okay, let's start with the oldest cases first. So that looks like that's 22-405. Actually, 22-407. I think 405 was a felony that went to the grand jury. That's probably the one you're talking about, possession charge.
Probably is, Your Honor.
So this is a domestic violence charge, 22-407. Debbie Wellman was the alleged victim. So one thing you need to realize, Mr. Little, if I accept your plea on this, this is a first-degree misdemeanor. I think Mr. Heald alluded to this, but if I accept your plea, this is one of those type charges like an OVI that is cumulative. It never goes away, and if you get another one, it'll be a higher level offense. It could, since you have a misdemeanor domestic, the next one would be a felony, which means you can go to prison on it. Do you understand that?
Sure.
And you still want to enter a plea to it? Okay. And that's a guilty plea?
Yes, Your Honor.
Okay. All right, I'll go ahead and send you on this. I'll impose a $200 fine, order you to pay court costs, 30 days in jail, and it will run concurrent with what he's serving now pending his felony cases that he has in common police court. Is there a no contact order or anything like that requested from Ms. Wellman? Do you have any information on that?
There's a protection.
22407 was the case number.
Okay. We would ask for a no contact.
There was a protection order issued. Okay, I'll issue a no contact order. Is that any problem to stay away from Debbie Wellman? If she doesn't want that, she'll have to come back to court and ask for it to be removed. Review hearing will be May 28th of 24. The next case is 22491. Should be 22491. Yeah, it should be a 22491. It's a violation of the protection order involving Debbie Wellman was the complaining person. I'll impose a $100 fine and court costs, 30 days in jail to run concurrent with his common pleas cases. Same review hearing date, May 28th of 24.
Contact order with Betty Williams.
Yeah, well, we don't have to enter that one. We're going to enter on that other day. That's sufficient.
That's what I need you, and then contact order. I gotta find Let me see if it's in here.
Next one is 23194. It's another violation of protection order involving Debbie Wellman. $100 fine. Court costs. 30 days in jail to run concurrent with common pleas. May 24th, May 28th of 24, sorry, May 28th of 24. There's a 194B and 195, all dismissed, they're pretty much related to the 194A. Factually, so I'll dismiss him since he is found guilty on the A case. Okay, I think that,
I believe that probably gets it up.
okay. Yeah, that's all.
Thank you, Your Honor.
You're welcome.
Six was on her. It's okay, sorry. Thank you.
I can probably do college.
State of Ohio recalls Kyle Akers, case number CRA 378, TRC 22, 25, 27, A and B.
All right, Mr. Soward's asked to be released off the bond that he posted in June. So I'm going to honor that. I'll set it, believe I need to set a new bond. I'll set a $5,000 cash or surety bond. It'll cover cases now.
Which one do you, this has the holder on him?
Should be, but 23378, 22, 25, 27. You want it on the 22, 25, 27. How do you want to proceed? Do you want to set it for trial, or how do you want it? That's the OBI. Okay. Let's do it pretty quickly though, since, yeah, that should be okay. Let me see. Yeah, December 8th. Be a pretrial on everything for Mr. Akers on December the 8th at 10 o'clock. So he has a new bond. 5,000 cash or surety. Robert.
State of Ohio versus Jonathan Sifford, case number TRC 2313, 132, A and B.
Means case. Okay, this is set today.
For pretrial, I believe, Your Honor.
Yes.
Your Honor, after speaking with my client and upon seeing your ruling on suppression in this matter and talking with Mr. Keel, we'll be entering a no contest plea, Your Honor, but stipulating a guilty plea.
All right. Is that correct, Mr. Sifford?
Yes, that's correct.
State have a position you want to take with regard to sentencing?
Your Honor, this is a first offense. The score, the breath score was .168. We don't have any opposition to treatment as a first offense.
Mr. Creans, either you or Mr. Sifford wish to say anything before sentencing?
Yes, Your Honor. Your Honor, in speaking with Mr. Hill this morning, we discussed the normal treatment, which before the court is a recommendation, which would be, I believe, either 10 or 20 days in jail suspended to the 3-day school, fine at your discretion, Your Honor, and we understand that that's going to be on the higher side of the scale. And, Your Honor, I believe that there would be a driver's license suspension going back 6 months to the date of the offense. It's been 9, so at this point.
Mr. Sifford, anything you wish to say?
I'd just like to apologize to you, Your Honor, and ensure you I will not be in here again.
And Your Honor, if I may, Mr. Sippert has a clean record.
Well,
Okay, and a college degree from OU.
I seriously consider jail on this one because your actions were totally unreasonable and outside the pale. And he's clocked at 100 miles an hour on a motorcycle on US 52 while testing, or later testing 166 or 168, whatever it was, very close to the high test level of 17 under Ohio law. So you put yourself and everybody else that was out on the highway at extreme risk. So I'm going to make your fine $830. Cost will be $110. You have a 6-month license suspension. I'm going to make your jail time 30 days, and I'll suspend 30 days, although I'm not sure I should. 30. What I'm going to do is increase your community service rather than give you jail time, because other than sending a message that your actions are totally unreasonable and unacceptable, the jail time doesn't really do any good for anybody in the community except cost them some money. So I'm going to double your community service. I'm going to make it 60 hours of community service. But you've got a month over your head if you don't do what you're supposed to do. I'll require you to go to the driver intervention program. And unfortunately, the only closest one is in Scioto County now. There's not one in Lawrence County, but that's mandatory. You have to do that or go to jail.
Okay.
So it's a 3-day program. I'll set your review hearing for May 28th of 24 at 9 a.m. Finish everything by then. You don't have to come back. You're going to meet with Mr. Major. You'll get all this information I'm telling you is going to be on a piece of paper he's going to give you. And you can always check it out. The court has a website, so you can check out your case there if you lose it or have questions about what you need to do. And he'll be your contact person with the court.
Okay.
Okay, on your speed offense, I'm going to impose a $150 fine, only because I can't impose any higher fine. If I could impose a higher fine, I would, but that's the max I'm allowed to impose. So a $150 fine on a speeding offense. And I think that's it. That's all the charges. Okay, you're to meet with Mr. Major, get this stuff done, get your community service done any day but a holiday or Sunday. You can work community service here.
Okay.
Any questions?
I don't believe so, sir.
Okay, May 28th, 9 o'clock is your next hearing.
Okay.
Thank you, Your Honor.
Thank you.
State of Ohio versus William Wilbur, case number TRC 23-272, A, B, and C.
This is Mr. Hameen's case. This is set for argument on prior motions.
Your Honor, I believe argument is submitted to the court. Mr. Hill.
Likewise, Your Honor.
All right, the case will be considered submitted, heard the evidence, memorandums have been submitted. I'll review those and issue a decision.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Shannon Ellis, Case number TRC 231630 A and B.
May we approach Your Honor on this?
Yes. What do you want to do? Maybe you want to have convictions. What are these seconds or thirds or there?
Your Honor, is there another case version other than 23?
Yes, there's two case numbers.
2315, third.
Thank you.
Your Honor, Ms. Ellis wishes to enter a plea to the two pending OVI cases and ask that the sentence be delayed so that she can complete the program that I've shared with you, and I'll make a copy for the court.
Is that correct, Ms. Ellis?
Yes, Your Honor.
And it's my understanding this is on an outpatient basis?
Yes, Your Honor.
How often are you in?
Once a week, and I attend meetings 3 to 4 times a week.
And there's also a psychiatric aspect.
I see a psychiatrist as well.
So that's,
And you do understand if you enter a plea to this, it is cumulative in the sense that if you have another one, it's going to be a higher level.
Yes, Your Honor.
And you still want to do it?
I do not plan on having another one.
Well, nobody does.
Yes, sir.
But I just want to make sure you understand how this will affect the future case if you have one.
Yes, sir.
Okay. Well, we've got a history with you being in this court as, well, prior defendant and working with people, as you know, so I know something about you, and I hope you'll be successful and take advantage of this, and I think you'll give it your best effort. That's
Yes,
what
sir.
I want to see. So the way this is going to work, I'll accept your plea today, but I'm going to delay the sentencing and let you go to treatment, see how you do, and then at some point I'm going to sentence you based on that. And I have a pretty wide latitude as to what I can do on sentencing, but then I have some requirements too. The state says I have to do on your case. So,
Yes, Your Honor.
do well, and we'll give you as close to the minimums as I can. Mr. Heald, anything you wish to say?
No, Your Honor, we just hope that Shannon does well in this treatment. I think she's probably committed to it. Hopefully she can continue to be, and hopefully be an example going forward to other people.
Okay, I'm probably then going to look around the 1st of January. Mr. Holt, December is pretty scheduled, and give her some time to get some of her sessions done.
sure. Would the 8th work, Your Honor?
Yes. So first, and probably won't conclude it then, but I just want to get a progress report as to how you're doing, but I'm going to put it down as a sentencing hearing, January the 8th, 10 o'clock.
Thank you, Your Honor.
You are.
Thank you, Your Honor.
State of Ohio versus Travis R. Valero, case number CRV 23435.
Joshua?
Mr. Holt's case set for pretrial.
Your Honor, Mr. Moxie is here, and he is the alleged victim in this. And I think there's some hard feelings going on and some things that really can't be resolved just by this case, having to do with other things, his ability to be a father and things of that nature, which he's going to have to address. And I think he understands that. We would offer, if Mr. Valero would be agreeable, to set this case out an additional 90 days. If there aren't any further problems between the parties, then we would be asking the court to dismiss the charges at that time with the payment of court costs.
We're agreeable with that, Your Honor.
And Mr. Moxie, are you agreeable with that? Mr. Moxie, are you agreeable with what the state's recommending?
Yes, Your Honor.
Okay. So February 26th, so around that time, Mr. Holt?
That works, Your Honor.
February 26th, time waiver from the defendant.
Yes, Your Honor.
Be dismissed then if there's no further problems and the court costs are paid. And I'll allow Mr. Valero not to appear. He's already paid the court costs and there hasn't been any problems. He hasn't paid the costs, or of course if there's problems then he needs to appear.
Thank you, Your Honor.
You're welcome.
Yep. Thank you.
State of Ohio recalls Kimberly Gannons, case number TRC 213329A. Kimberly Gannons.
Okay, she had negative screens.
Yeah, first one.
Yes. Okay, well, they're recommending that, do you want to go back, or what's your position on the treatment? I know there's been some failed screens, but it seems like you were claiming that there was something about the screens that was wrong, or, is that right? No?
No, all of my screens there's been negative.
Well, that's not what Bethesda's saying. And testing positive for the worst thing you can possibly test for that's out in our community right now. The thing that's killing lots and lots and lots of people across this country.
That day.
Although your screen today here at the court was negative.
May I speak?
Yeah.
Okay,
That's what
sorry.
I'm saying.
I get nervous. I would like to I've done everything you asked. I've been doing this since June. And I have been passing my drug screens. I don't know.
Well, I don't feel like I can, you have completed your community service, your fines and court costs. But look, I've got a screen from this court you did in August that said you were positive for fentanyl. Then I've got Bethesda saying you tested for fentanyl with them. And then I've got today you were negative. I don't feel in good conscience I can let somebody go back out in the community if they're using fentanyl because you could wind up dead.
I understand that, Your Honor.
And I would say this too, not just to you, but everybody's listening, and you probably know this. Anything you get out of the community off the street to take could be fentanyl. People that are selling drugs, not in a pharmacy, but off the street, they don't know what's in it. And we're seeing fentanyl show up in a lot of things that people don't think they're getting fentanyl. That's why the last year was the most overdose deaths in the United States ever. Ever. As bad as things were when we were seeing lots of heroin, not seeing that much heroin anymore. Fentanyl is 50 times stronger than heroin. And the people that are mixing it up, they're not chemists. And they're not doing it in a lab under controlled circumstances. They're doing it in a warehouse or a garage or somewhere like that. So you don't know what dose you're getting. That's why people are dying. So I want you to continue with Bethesda. I want to see some...
Maybe I can make a recommendation. Since she has, her date of admission says 3/13/2023, maybe we could get her reassessed to see where we're at as far as the counseling's perspective.
Okay. And go along with that. So I just want to make sure you're good and you're not going to be seeing positive fentanyl tests. So I want you to come back. Let's set it for January the 8th, your next hearing. 9 o'clock. Continue with Bethesda.
Thank you, Your Honor.
State of Ohio versus Christine B. Shipman. Case number CRB 23698. Christine Shipman.
Is that you, man?
It's Kirsten Shipman.
All right, Ms. Shipman, and you've received a copy of the charge? Okay, the bail's about to hand it to you. The charge alleges that November 22nd of 2023, in Fayette Township, you tried to defraud Walmart of property without their consent. It's a theft charge. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
Do you understand your rights?
Yes.
Were you here when I explained the rights of defendants?
Yes.
Any questions before you enter a plea?
No.
What plea do you wish to enter?
Not guilty?
You want a lawyer appointed to represent you?
Yes.
Do you have a job?
No.
You have no income coming in?
Not at the moment.
Mr. Thompson, I'll appoint you. I'm entering a not guilty plea for Ms. Shipman. I'm looking at, I think you still want Mondays, right?
Please.
December 8th is not bad. Is that good for you?
It's fine.
I'm sorry, that's a Friday. I was going from memory. Let me pull up the calendar. So I'm looking at exactly what's on the calendar. We can do the 11th or 18th. Those are both Mondays.
Let's do 18th, if you don't mind.
All right, December 18th will be the next hearing. Be a pretrial at 10 o'clock.
Thank you.
You're welcome.
State of Ohio versus Kenneth R. Hill, case number CRB 23699. Kenneth R. Hill. Kenneth Hill. Kenneth Hill. Kenneth Hill.
All right, Kenneth Hill was cited to be in court actually today. He received the summons yesterday, ordered to appear today, has not appeared, so it'll be a warrant issued for failure to appear.
State of Ohio versus Colleen L. Bryant, case number CRB 23657.
And one of you is Colleen Bryant.
It's me.
Okay, and she's in treatment?
Yes.
You have a report? Excuse me. All right, Ms. Bryant, you're charged with unauthorized use of a motor vehicle. It's alleged that at Windsor Township on October 26th of this year, you not only used a 2000 Pontiac Bonneville, that you did so without the consent of the owner. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
You understand your rights?
Yes, sir.
How do you plead to this charge?
Not guilty.
Do you want a lawyer appointed to represent you?
Yes, sir, appointed.
And you're not working, I take it?
No.
Mr. Stratton, I'll appoint you. State's position on bond. She's in the sober living facility with Florence County Recovery.
Your Honor, if she stays in treatment, we're okay with no R bond. And her father's here, he's the alleged victim in this, and he wants her to stay in treatment. So we're willing to, with a time waiver, allow her to be successful in treatment, and if she's concludes that satisfactorily, then we could maybe dismiss the charges later on. We want her to be successful in treatment first.
Okay, yes, Your Honor, that's
That's
fine.
agreeable?
That's agreeable.
She can sign a $2,000 signature bond. I'll add the additional condition that she must stay in treatment as part of her bond. And it's my understanding she's previously been at Lawrence County Recovery. So no leaving this time, okay?
She completed successfully the first time.
Okay. I thought there was an issue.
There was an issue. She had decided to stay. I did bring a copy of her certificate that she had received previously.
I think she was discharged, according to this, discharged for noncompliance from the outpatient.
Yes,
part.
she decided to stay longer after receiving her certificate. And after that is whenever some issues came up and she was discharged.
Okay. Well, I'm leaving you out of custody on the conditions you stay in treatment. So it's if you want to leave treatment or do something different, you're going to have to run it by me and get permission, and I'm not likely to grant that. So stay in treatment.
Yes, Your Honor.
December 18th?
Yes.
December 18th will be the next hearing for pretrial at 10 o'clock.
State of Ohio versus Tory Lindsay, case number CRB 23642, A and B. Tory Lindsay.
Hi there. I met you in person.
Mr. Scott's case set for pretrial.
That's correct, Your Honor. Judge, I spoke to my client, I spoke with Mr. Hill this morning. We believe we have a potential resolution to this matter. If I recall, and correct me if I'm wrong, Mr. Hill, be suspended jail time, community service, and whatever fine this court imposes in exchange for a guilty plea.
And we are agreeable with that, Your Honor. And there's also a criminal trespass. So we would ask for an enhancement.
Usually that means there's been a prior conviction.
That's probably the case.
I believe the criminal trespass comes out of a previous stowaway order from Walmart. So we would reiterate, stay away from Walmart.
Yeah.
Go to Target.
Right.
All right, so there's a plea entered to the A and B case, theft and criminal trespass, is that correct?
That's correct, Your Honor.
All right, I'm going to order Ms. Lindsay submit to your screen before I actually sentence her. So go to the probation office to your left, submit to your screen, and then come back and I'll sentence you after I get the results.
Your Honor, may we approach briefly?
Yes? Okay. All right, go do your screen, come back, and we'll decide what the sentence should be after that happens.
Mr. Scott, you're next. State of Ohio versus Melissa Wheeler, case number TRC 231295, A and B.
Judge, this is mine, this is a DUI case, alleged DUI case. Again, Mr. Hill and I spoke this morning, we believe we have a potential resolution. Ms. Willard is in treatment at ARC. In exchange for a guilty plea on this, we would delay sentencing, allow her to complete ARC, and then do first-time OVI treatment at sentencing.
Mr. Hill?
We're agreeable with that, Your Honor. Right now, it's a, excuse me, first offense with a refusal and an additional in 20. We would like to see Ms. Wheeler be successful in treatment, and if so, we could take a little better look at a disposition that might not include jail time if she's successful in her treatment. So what we would recommend is a plea today, delay sentencing, have her finish her treatment, come back at a later date for sentencing.
What plea does she wish to enter?
At this point, we do a no contest, Judge.
Do you waive a reading of the...
We do waive.
Stipulate to finding her guilty?
Absolutely.
All right, do you agree with, so in effect, you're not admitting that you're guilty, but you're stipulating that there's enough evidence to find you guilty. Do you understand that, ma'am? Yes. And you agree with it?
Yes.
Is there anything you want to tell me now before I decide how to go forward?
No, sir.
You have a right, you don't have to, but you have a right to make a statement. You don't have to make a statement.
I'll make one on her behalf, Judge. I've spoken with her pretty well at length. This is the first offense she's had in over 10 years, and she's doing everything she needs to do to rectify this with the county and this court.
And did you say she's at ARC?
Yes, sir.
Are you a Kentucky resident, ma'am?
Ohio.
And they take, because that's, you're going to Kentucky then for treatment, right?
Yes, sir.
And they'll take you?
Yep.
Okay, because that's what I know them for, is treating Kentucky residents. I didn't know that they could, you have Ohio Medicaid, or how you pay for medical services?
Through work, my job.
Oh, you got insurance?
Yes.
Health insurance?
Yes.
Okay.
Ms. Willer is full-time employed. She works nights and has still made significant efforts to be here each and every time.
Okay. Well, what we're going to do, I'm going to accept your plea today. I'm going to delay the sentencing, though, let you go to treatment at ARC, and they do work with this court, so they'll give me some reports as to what you're doing. That's what I want to see. I want to be convinced that you're dealing with any issues and that you're resolving them, and you're not going to be coming back, or in this court or any other, with similar type of cases. You understand? So that's what I want to see. So let's go probably 1st of January sometime for the next hearing.
Is the court in session on the 2nd, since the 1st is a New Year's Day?
That would be, actually would be the 3rd. The 2nd is New Year's Day.
I can actually do the 5th.
Well, I'm sorry, I'm looking at the wrong year.
No, we're in on, we have a court on the second.
I was looking at 23, so, yeah, it'll be the 2nd.
Okay. I misspoke. I'm actually unavailable that day. I can do the 5th, though, that same Friday.
Okay, that's fine. I'll make it January 5th for sentencing at 10 o'clock. And make sure you tell the people at ARC that you're in this court and you need a report from them as to your progress.
Okay. Thank you, Judge.
You're welcome.
State of Ohio versus Daniel Lucas, case number DRC 231414, A, B, and C.
Mr. Smith's case.
Yeah, First Your Honor.
Yes, and Mr. Lucas is at RRS.
Yes, sir.
Yeah, I'd like to put a definite on that amount of time to, if it's possible, to, so I can make a note of it. 27 days, Jim. When did you start?
30th to the 27th, September, October.
Okay. Just make sure you get credit. It was only 30 days in September, so it probably wasn't early. It went to October 27th.
Okay, it's a good report.
Thank you.
What's the state's position on how to proceed?
Really? Your Honor, if he enters a plea today and goes to treatment, we don't have an opposition to delaying sentencing. Right now, it's charged as a third offense, but it's also my understanding that he did almost a month in jail before he bonded out. So he does have some credit there banked in his favor. But we would be okay with delaying sentencing if he wants to go ahead and plead today.
Judge, I've spoken with Mr. Lucas out in the lobby before coming in, and he intends to go ahead and enter a plea today. He's doing well in treatment. He wants to stay in treatment. In fact, if there's aftercare, he says he'll do that. He seems sincere to me to want to get some help and get this issue resolved.
So there's a guilty plea entered today?
Yes, Judge.
Is that correct, Mr. Lucas?
Yes, sir.
I'm going to delay the sentencing, give you a chance to continue with your treatment, and, you know, I can be as lenient as I possibly can be if you are successful in treatment.
Yes, sir. I appreciate that.
Your Honor, is there an indication in the file as to the bond and when it was posted?
There's an OR.
I gave him a $5,000 OR with an ankle monitor. You still have an ankle monitor?
He does. It's been on for a month. He just was asking me if he could consider have that removed.
I'm not going anywhere. I'm going to work my program.
I know you hear that a lot.
Your Honor, he's actually a model client, and I don't see any reason to keep the ankle monitor on.
Was that done on October the 27th?
You know, this is all being recorded, so.
Yes.
You're in the hot seat.
I've been wrong myself before when I said,
Yes.
oh, he's good. We'll take the ankle monitor off.
I have no intention.
Here they go.
I've had that happen a time or two.
The bondsman, is that what you could have come up with?
I couldn't come up with a money.
He's got no R bond now.
Well, I just wanted to make sure that we knew that how many days credit he had, so that if we have that discussion in the future, we know. So he was arrested apparently on September 30th when this happened.
Correct.
And at some point, he got out to go to treatment, I
October
guess.
27th.
So I
It's
just
like
want,
October 27th.
He
is when the
was
ankle
in-
monitor was ordered.
Today's 1 month.
okay.
And he says he was in jail that entire time, so that will certainly help on the back end, assuming he does his part with the front end, which is the treatment.
And I plan on.
Okay.
Well, I'm assuming since he's wanting to get leniency on sentencing and show that he's got to be compliant with treatment, there's going to be a time waiver anyway, isn't there?
Oh, yes, there's a time waiver.
Yeah.
Oh, yes, yeah, we have no
Okay.
objection. Yeah, we will certainly sign a time waiver.
Well, if he's
He'll hand me
pleading,
one.
he's pleading though,
Yeah,
so we won't need a time waiver.
you sure? Okay, well, either way, we're not opposed to it. It's to his benefit.
Let's do January 12th, if you're available.
Let me see if I did. That sounds far enough.
Your Honor, I'm sorry, is the monitor to remain on or be removed?
I'll order the monitor removed.
Appreciate that.
That should be fine, Judge. I started a trial with Judge Farrell on the 9th, but it's just blocked off for 3 days. I can't see it going into Friday,
Okay.
so I can do that.
January 12th, pre-trial, 10 o'clock.
Would that be sentencing, Your Honor?
Yeah, it should be a sentence, I'm sorry, it should be a sentencing. Ankle monitor ordered removed. So see Mr. Major about that.
Patient. Thank you, Judge.
You're welcome.
See you then.
Thank you, Your Honor.
Thank you, Your Honor.
You just let him know.
Good luck.
Thank you.
State of Ohio versus Shelby N. Rodriguez. Case number CRC 23396, CRC 23816, A, B, and C. Shelby Rodriguez.
This is Mr. Smith's case.
It is, Judge. We've had several pretrials. We're just not getting any traction or close to resolving it. What I would ask is the 5th, 12th, or 19th of January set for a bench trial, and maybe come back the 15th or 22nd of December for a final pretrial.
All right, I'll set it for trial on January 12th.
Yes, sir.
At noon.
Yes, sir.
And
I'm here the 15th or 22nd of December, perhaps a final pretrial case, which is better.
the 15th is okay. December 15th for a pretrial. Be the next hearing.
The 15th at 10 o'clock. 12th of January is noon. January 12th is noon, that's the trial date. Yeah. January 12th, 24th, noon. That's the trial, we'll come back for a final pre-trial, 15th of December day. We're going to pick the trial date because we can get more back.
State of Ohio versus Mary Cecile Ellen Taylor Rubin. Case number CRB 23622. Mary Rubin.
Will you? Yeah, I'll do that for sure.
This is also Mr. Smith's case set for pretrial.
Claude Pater here.
Hey, Roger. Judge, this is one I thought we might also be setting for trial, but it sounds like the state needs to have another conference with the alleged victim. If we could use December 15th as a pre-trial and not even set a trial date yet, because this may very well get resolved.
All right, defendant's request case is continued to December 15th for a pretrial at 10 o'clock.
State of Ohio versus John F. Wright. Case number CRB 23113. John Wright. Did not check in.
It is. Judge, he's got a case in common pleas. We have been intentionally putting this behind it because that involves an alleged probation violation. Even if he entered a plea here and got no jail time, that would still affect his probation violation. He had been in the hospital in Columbus. I understand he's now out of the hospital. I believe Judge Ballard has issued a habeas. And he's supposed to go back to a step-down type hospital, long-term acute care hospital, but to my knowledge, he's waiting for a bed, but he is not here today, and I know there is a case
He's got
outstanding.
7 days to appear or a warrant will issue.
I will get a hold of you, Judge.
State of Ohio versus Christina Don Webb, case number CRB 23586.
Mr. Smith's case, pretrial.
Judge, this we would like a final pretrial December 15th. If it's not terribly crowded, go ahead and pick a trial date, either the 5th or 19th of January. We just said rather than the 12th, so I can do the 5th or 19th of January.
Okay.
And we'll waste time. It's an M4.
So you want a trial date set?
We could, yes, either the 5th. We've been here a couple times, Judge, and we're making very small, if any, progress. I would like to do a trial, bench trial, the 5th or 19th of January, with the final pretrial the 15th of December.
Mr. Hill?
And that's fine, Your Honor.
December 15th will be pretrial.
15th at 10.
10 o'clock, yes. That's the next time.
And then I'm coming back.
Yes, January. I'm sorry, what day did you say? Are you still looking?
I'm looking at the trial.
Okay. Still looking for the trial.
5th, or what was the other day?
The 5th or 19th. We set another bench trial on the 12th just now, so I can do the 5th or 19th.
Okay, let's make it the 19th, then. January 19th for trial, I think.
We did do something. I'll see that.
You not do this?
Oh, no, you're good, Nat. That's a bond. You don't need that. All right.
State of Ohio recalls Tory Lindsay, case number CRB 23642, A and B. Tory Lindsay. Tory Lindsay.
She hasn't came back in yet. I think she's still maybe probation.
You want to see the screen? There was more than what she...
Tory Lindsay? Tory Lindsay.
Back up, your turn. There are.
Judge, in light of the returned drug screen, we would ask that outpatient treatment be considered an option in addition to the previously discussed sentence. Reason for outpatient, Ms. Lindsay does work full-time. She does maintain a home, has pets. So we worry that inpatient may be too much of a burden. On the onset, we would ask that we do outpatient and see if she complies before we go to inpatient, if at all.
Where are you working at?
Everclean Janitorial Service.
Where's that located?
They have an Ironton office and a South Point office. It's commercial cleaning, residential cleaning.
How do you pay for medical services?
I don't have a medical card. That's something that I'm working on trying to get, because I just moved up here, so I have to try to get medical insurance.
And you're assuming from what you're saying, your employment does not furnish you with any kind of health insurance coverage?
Unfortunately, no. I don't believe so, at least. I'm not under the impression that they do. But I would definitely do whatever I have to do to get the medical insurance if I could possibly.
Well, you're living in Ironton?
Yes, Your Honor.
You drive.
My license.
Okay.
My license.
Are you paid by the hour?
Oh, yes, sir.
How much per hour?
$9.50, I believe.
She may be eligible for Medicaid anyway. Is there someone that could evaluate her? Okay.
I spoke with her earlier, and due to what she did with recommend resident treatment, I didn't do an assessment or anything like that on her. I just spoke to her and we just talked about it.
Yeah.
I just wanted to think that was
Sure. Absolutely.
Do you have children or anything, or?
No, sir, just a dog that I consider my child pretty much, but no, I do not have any biological children myself.
Have you done treatment before?
No, I have not.
Judge, Miss Lindsay just told me she's never done treatment before. Yeah, but my theory on this is try the least restrictive means and then advance if necessary. So we'd ask this court to strongly consider outpatient on the onset.
And you're living in Ironton, correct?
Yes, Your Honor.
So is there anyone here that's got an office in Ironton that, can you try her on outpatient for a couple weeks?
I would have to talk with Kathy that works with me to see if we could try her application, but,
And the reason I'm willing to do it is because she has an appointment. So that's two of my conditions. If somebody's working or has kids, then I'm more willing to try outpatient first.
well, I can make a phone call and.
Well, we do that, and then the next option may be amended reads, try to see if they'll do it. They're in Ironton. So I'm going to recall this, let her talk to her supervisors and see. You tested for a lot of stuff, though.
Yes, Your Honor, like I had told him, I was upfront and honest about the buprenorphine. I have 3.5 years clean off of fentanyl, and I felt as if I was gonna relapse, so I did do that, I admit that. The methamphetamines, it was just a slip of judgment. I'm assuming that the amphetamines and the MDMA was inside of the meth, which I know that's the risk I take doing street drugs, you don't know what's in it, but I just don't want the court to think that I was out just having a big party with all them drugs. It was the 2 drugs that I admitted to. I'm just assuming that it was mixed, which I know that's the risk I take, and it was a dumb decision. I take responsibility for that. But I do apologize to the court, so.
Okay, well, let's get you back on the right course. And so I'm going to recall your case. We'll research this some more and see what's available for you, and then we'll make some decisions. So
okay, so
the case
just
will be recalled.
Yeah,
have a seat here.
step outside and talk to her, okay?
Okay.
Thank you, Judge.
You're welcome.
State of Ohio versus Stephen J. Febo, case 23-700.
Stephen Febo, F-E-B-O. Copy your charge. Sir, are you Stephen Febo?
Yes, sir, I am.
Mr. Febo, it's alleged that on November the 24th, by threat of force, you knowingly caused Jessica Ferguson, who's either a member of your family or a member of your household, to believe that you were going to cause her imminent physical harm. That's domestic violence is the charge that's been filed against you. It's a 4th-degree misdemeanor. It carries a maximum penalty of 30 days in jail, $250 fine. Do you understand the charge?
Yes, sir.
And do you understand your rights?
Yes, Your Honor.
Do you have any questions about your rights?
No, sir.
Or about the charges?
I deny the charges.
Okay. Well, that was going to be my next question. What plea do you wish to enter? So you want to enter a not guilty plea?
Not guilty.
Do you wish to be considered for a court-appointed lawyer?
Yes, sir.
Are you working?
I'm retired, Medicare, Medicaid.
Do you get a pension?
Small,
How much?
just a little over 300.
300 a month? That's all you're getting?
Yes. 340 something.
Okay. You're eligible for a court-appointed counsel then. Mr. Steyer, I'll appoint you.
Hi.
State's position on the bond.
state's not opposed to an OR bond as long as we also are assured that he's not going to be around this first.
That's fine. Well, I didn't see it before, but he has posted a bond, so the bond is posted, I'll continue it. Is there a protection order request?
Yes, Your Honor.
Is it a problem for him to stay away from Jessica Ferguson?
She doesn't live where you live, does she? Talk to me, not to her. Does she live there?
No.
Okay.
She does not.
Does she use it as a mailing address?
Yes, that's her mother's.
All right, so the alleged victim doesn't live in the home that he lives in. However, she uses it as a mailing address. So I don't think there should be a reason for him to have to stay away from her necessarily. But, I mean, if she may show up there, it is apparently her mother's home.
Okay. Well, I'm ordering you to stay away from her. I don't want there to be another alleged incident. So the best way to stop that is you just stay away from her, at least till we come back to court, so.
Yes, Your Honor.
Don't let her come in, just stay away from her, tell her there's a court order for you to stay away from her. And you retreat from her, she comes around you.
Yes, sir.
And when would you like to come back for the next hearing, Mr. Steyer?
Other than this Friday, I'm available all the immediately upcoming court dates. So I don't know what's the best day for the court's calendar.
Actually, December 4th is not terrible.
I'm here that day, Your Honor.
Let's do that. December 4th for a pretrial at 10 o'clock.
We may have an issue, Your Honor. I apologize. He may have a doctor's appointment that day. He's going to check his calendar. Might be the one above that.
All right, tap the same one twice.
No, that's the same one.
Here,
Okay.
1 second, sir. No,
We're good?
I'm good.
Okay, we're good that day, Your Honor. I apologize.
December 4th at 10 o'clock for pretrial. There's a protection order issued. Next hearing is December 4th, 10 a.m.
Wait out there. I'll keep this complaints, okay?
Thank you, Your Honor.
Thank you.
You're welcome.
State of Ohio versus Gage Henson, case number CRB 23702.
Through your Gage Henson,
Yes, Your Honor.
bail sent you a copy of the charge. The charge alleges November 24th of this year, Perry Township, you knowingly caused or tried to cause physical harm to Alexandria Howard, that she's either a member of your household or a member of your family. It's a first-degree misdemeanor domestic violence charge, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, Your Honor.
Do you understand your rights?
Yes, Your Honor.
How do you plead to this charge?
I would like to plead not guilty.
You want a lawyer appointed to represent you?
Yes, Your Honor.
Do you have a job?
I have an orientation that I went to, but where this happened, like today was supposed to be my first day, but I couldn't because we're at court today. So I have a job, but I haven't received the first check or anything yet.
Where will you be working?
UPS.
Okay, well, that's a pretty good job. What's the starting?
I don't know.
Don't even know?
Yeah, I've just been to the orientation and they
You
were
have
supposed to
any
send
money
me a message for my first day of work through text message, so.
Yeah, well, you may not even have that job anymore. Do you have any money saved?
Not a lot, but
Have you been working?
yes.
Where?
AWP, it's traffic control flagging for construction and road, like paving and stuff.
Okay, how much were you making there?
Around $12 an hour, around $400 a week after the hours.
Okay, and I see there's children. Got a
Yes, Your
couple
Honor.
children?
Yes, Your Honor.
All right, you're eligible for court-appointed counsel. So, Mr. Scott, I'm going to appoint you.
Thank you, Judge. We agree that he's not guilty on the charge, on the issue of bond. He's here, he showed up on his own free will.
He's got a bond up.
Does he have a bond up? Okay.
His bond is continued. State's position on protection order.
Ms. Howard is here, the alleged victim. She does not wish to have a protection order. However, she says that they won't be staying together. So,
So you don't want him ordered to stay away, but you don't want him to come back home to live. Is that my understanding?
What is that? I'm sorry.
You don't want him to come back to the house to live, is that correct?
Yes.
And you're
Yes, Your
agreeable
Honor,
with
that
that?
is, yes.
So we need a hearing date to come back.
Judge, the state can have discovery item available this coming Friday, December 1st. Maybe get a quick resolve on this.
Mr. Hill?
we don't oppose that.
All right, next hearing is this Friday, December 1st, for pretrial, 10 o'clock.
So the protection order is removed, so I can like get my kids while she's
Yeah.
at work?
Here, you can go around here, no breach of the peace, though.
Yes, sir.
I'll explain more to you.
Okay,
That's why I step outside.
Thank you.
Thank you,
Your
Judge.
Honor.
You're welcome.
State of Ohio versus Christopher J. Blevins, case number CRB 2286, TRC 21595 A and D, CRA 21162, CRB 21165 A and B.
Yes.
Wonderful.
Okay, it's an excellent report,
Very good.
Mr. Blevins.
Thank you, sir.
How you want to proceed, Mr. Stratton?
Your Honor, he's doing very well. He's done the best he's ever done before.
Agreed. Agreed.
Working 40 hours a week. He's been clean for a while now. 4 months today. 4 months today. However, the state wants to proceed with it, but
I'd like to see more time clean. Because 4 months is noteworthy, but it's just a start.
Yes, Your Honor.
It's a good start, but it's just a start. So we need to get more time.
All righty.
Well, I guess I should let Mr. Hill speak. I don't know.
Well, we agree with that. We're happy with his progress. It looks like he is too.
Yeah.
And so that's encouraging. We just need a little bit more time to make sure, put him on solid ground.
Let's come back in January.
Yes.
About the 19th,
Yeah, that'll work.
January 19th, for pretrial. Good job, Mr. Blevins. This is by far the best I've seen you ever do.
Thank you so much.
State of Ohio versus Aaron McCoy, case number CRB 23534.
Your Honor, there's a cross-filing this, on this case for Jason McCoy also.
And that's Mr. Thompson's case.
State of Ohio versus Jason Nicole, case number CRB 23-537.
Yes.
That's where I'm at. No, you're starting to charge her for the argument. Same thing, just copy for everybody.
She does have a marijuana card, Your Honor, so you see that.
Is there a report for Mr.?
He is now at Pat.
Is there a report from Pat?
Yes, sir. Yeah.
Yes.
It doesn't apply to you.
How's the state want to go forward with this?
We would like to see them continue on the path that they're on, complete their counseling, and if they're able to do that, then we're going to be happy to ask the court to dismiss the case with the payment of one court costs, and hopefully this is something they're gaining a benefit from.
Yes, sir.
Yes, Your Honor.
It sounds like it's agreeable to the...
It is agreeable.
January 22nd, or see, that might be a holiday. It's not?
The 15th.
Okay. January 22nd.
Is that a
Yes.
Monday?
It is a Monday.
Thank you.
Continue with your counsel.
Well, she wrote it down. Yeah. At that time, Thank you.
State of Ohio versus Jennifer Cooper, case number CRB 23-506, PRC 23-11-27, AG decision. And case number CRA 23-507.
She completed it. And she's going to use for outpatient on Monday or Tuesday.
There should be one of those in there for... This one's the man we don't need here. Jason's in there.
Okay, she's finished up inpatient, or there's a recommendation for outpatient.
She's gonna come in for an assessment tomorrow, Your Honor.
Okay. So is it appropriate time to sentence now, Mr. Hill, or do you want to continue to monitor before we do the sentencing?
Well, we have the CRA case that's still pending. We're going to want her to continue on with her treatment with respect to that one, so.
Okay.
Either way is fine with us. It's a first offense.
Well, let's do one more to get her settled into her outpatient, and then maybe we can resolve things in, at least as far as sentencing goes. Let's go toward the end of January. So January 29th, preliminary hearing and sentencing. Okay. Good work so far, Ms. Cooper. Keep it up.
Thank you.
State of Ohio versus Dwayne Shadley, case number CRB 23663.
Mr. Steyer's case, set for pre-trial. Stab dues at Shawnee.
I believe there's a co-defendant as well, Your Honor. Although I don't know the name off the top of my head.
We can deal with them separately.
Okay. Have you gotten a copy of this?
I do have the report from Shawnee.
Or do you have a copy, or am I doing holding on to one?
Yes. Yes.
Okay, perfect. Got it.
Okay, it says he's fully compliant.
Yes.
Your Honor, this is pretty good report. It's a 90-day program, so we've got a little bit of time to go in it yet. It's my intention then to file discovery, see if we can, Mr. Hill doesn't have a video, I'd like to see if a video exists as a Walmart case, and the existence or non-existence of the video is pretty telling. So I'd like to have a chance to take a look at that issue, and so I'd ask to come back at court's earliest convenience. I think Mr. Hill can usually get that information from Walmart fairly quickly, so.
December 4th, is that too soon?
That might be a little too soon. Also, I have at this point about 12 cases on that docket myself.
December 11th?
So the 11th will be fine, Your Honor.
December 11th will be the next hearing for pre-trial, 10 o'clock.
State of Ohio versus Brittany Eplin, case number CRB 23589 A and B.
Need Mr. Morford. He's coming. Set for pre-trial.
Can I approach, Your Honor?
Yes. you reviewed the report?
I have, Judge. Looks like we need to do some more work and buy harder into the program.
Okay. Agreed. Mr. Hill?
We agree. We need to see
She's willing to do that?
Yes, sir.
Okay. I think maybe we need to come back December 29th. December 29th will be the next hearing, pre-trial. Okay. Keep working.
Thank you, Your Honor. Thank you.
You're welcome.
State of Ohio versus Ben Smith, case number CRB 23662.
All right, Mr. Morfer, I think this is your case.
Sorry, Judge, I was trying to find
He's just getting started, but it looks like everything is going the way it should at this point.
Yes, sir.
Is that correct, Mr. Smith?
Yes, sir.
Mr. Hill?
Well, we're happy that it's got a good start. We have to deal with the underlying reason why it's here, and that is the charge. So we'd like to see that resolved as soon as possible. I believe we've provided discovery.
Yes, sir.
How do you want to proceed, Mr. Morford?
Judge, I'd like to see him continue. He said he's just beginning, and he seems to be doing well.
Is there going to be a contest over the charges, or do you know that yet?
I don't know that yet, Judge.
Can you let us know at the next hearing, please?
Yes, Judge.
Other case that went with Wayne Shabu?
I'm not sure.
He is, and actually,
He is?
Mr. Steyer asked about video, and we do have video.
Okay.
He's for 12/11, do you want the same day?
Yeah, we put it the same day, December 11th. Pre-trial, 10 o'clock.
I'm your time. Thank you, Judge.
You're welcome.
State of Ohio versus Brian K. Stapleton, case number CRB 23593, CRB 23983, CRB 2257.
Mr. Morford's case, pre-trial.
Is Alexis Rice here?
Yeah.
Can you come up here, please? Ms. Rice here with me is the alleged victim. Mr. Stapleton is her stepfather. And it's my understanding they are living in the same residence. And we had discussed the question of whether anger management counseling was an appropriate thing to request as a resolution to this. And Ms. Rice tells me she does not believe that it's necessary. The main thing we want to do, if they're going to continue to reside in the same household, we don't want new charges coming up, first of all. And we want there to be peace, and if we can accomplish that for a period of time, for 90 days or so, without any problems, we don't have a problem with recommending a dismissal of the charges with the payment of court costs at that time. I know that Ms. Rice means well. She's a young lady that's living in this household of her stepfather, and hopefully her request that he not do anger management counseling is out of respect for him. But we'd like at least further discussion about it. We'd want to make sure that there aren't problems in the household. So would he be willing to do anger management counseling?
Do I have something you have to, will you take do that? I work out of town, so I don't know how I can do that.
That poses a little bit of a difficulty, Mr. Hill. He works out of town. Is there some way he can do it on the weekends, perhaps?
I don't know if that's offered or not, honestly. I guess what we'd like to do is this. The idea would be a 90-day type continuance, but we'd like to check in on it a little bit more frequently than 90 days if that's possible.
Well, there's also this, okay, that is her case, the assault, and then in addition to that, looks like there's a traffic case that he's pled to, and the charge involving theft where there's restitution too. So he did make a payment on November 2nd. Okay, so those matters are still pending too. Come back in 6 weeks then, instead of 90 days.
Okay.
January 8th.
I'm good, Judge.
January 8th is the next hearing, 10 o'clock.
Thank you, Your Honor.
Federal High versus Randy Thompson, case number TRC 23-1301, A and B.
Mr. Morford's case has a retrial.
Judge, I'm sort of keeping my distance, if you're wondering. He says he might have COVID.
Okay, you want a continuance then?
I think it would be a good idea. It was my understanding, he called my office earlier, excuse me, today, and said he was headed to the hospital.
Okay, let's get him out of here then. Let's see. December 18th, should be over whatever he has by then. December 18th, 10 o'clock will be the next hearing.
Thank you.
State of Ohio versus Jordan Barber, case number TRC 231616. Jordan Barber. Jordan Barber.
It's Bartram.
Bartram.
Jordan Bartram. And I had down that you hired Mr. Haslam, is that right?
Mr. Haskamp, but he couldn't attend today due to being sick, sir.
I'm not familiar with that attorney. Where's he located?
I think he's located Upper Ohio area.
Judge, this is a case that was referred to be by Matthew Lombardi. I handled some cases in this end of the state for him.
Okay, so are you going to be appearing then?
I am, Your Honor.
Okay, I'll put you down as counsel. This is the first pretrial.
Judge, I'm going to have to request a short continuance. It doesn't appear that Mr. Lombardi has filed discovery.
Well, there was a motion for discovery filed by Mr. Haskamp, I see in the file.
Mr. Hill doesn't have that one.
Okay.
When was that filed, Your Honor?
November the 5th, and it looks like it was served to the prosecutor that day by fax. It says 740-533-4387.
Okay, we'll follow up with it.
When do you want to come back then, Mr.?
Judge, a week is fine, or 2 weeks, whatever's best with your calendar.
Mondays are in December are the best, 4th, 11th, 18th.
I'm good any of those days.
When can we have the discovery included?
What date was requested?
With
The 4th, well, either the 4th, 11th, or 18th.
We can have it by any of those dates.
Okay, let's do December 4th. December 4th, 10 o'clock will be the next hearing.
Wait a minute. You're good to go.
State of Ohio versus Charles H. Dennison, case number CRB 23566.
Where's his attorney?
All right, I have Mr. Nash down as the attorney.
He is not here.
Okay. We'll have the clerk contact him, just have a seat and we'll try to get a hold of him.
Judge, if necessary, I can step in for Mr. Nash and ask for a brief continuance.
Okay, do you know if he's not going to be here?
Yeah, I just checked, he is not here.
Well,
I'll call his cell phone right now and see.
We'll recall, we'll see if he's on, maybe he's coming.
State of Ohio versus Robert Toller, case number CRN 23671. He has been picked up.
All right, Mr. Toller was here on an extradition to the Kentucky Parole Board. They have picked him up, so the case here is dismissed.
State of Ohio versus William Edward Pitts Jr., case number CRA 23-660. He has been picked up by Virginia.
All right, this was also an extradition to Virginia. He was picked up by Virginia, so the case here is dismissed. William Edward Pence Jr.
State of Ohio versus Charles H. Dennison, case number CRB 23-566.
Judge, I was able to speak with Mr. Nash. He had a scheduling issue on his end. He asked that I step in and cover for him today and that we continue this to this Friday.
Did you have a decision? I was behind my turn. Just
We are okay with that with a time waiver.
Okay, well, since it's at the defendant's request, there'll be a time waiver. So it is continued to December 1st at the defendant's request for another pretrial, 10 o'clock. December 1st, this Friday.
Okay, you're good to go. So come back Friday, okay?
That's yours. All right, thank you.
Thank you.
Thank you, Lord.
State of Ohio versus Jonathan Jones, case number CRB 22686, CRA 22685, CRA 23679.
This is Mr. Steyer's case.
Your Honor, if I may, RRS transferred here today with having some issues with RRS. I'm going to put him in the back. Put him on the back today.
You probably haven't had a chance to talk to him yet.
No, I just became aware he was here. I don't have my file with me. If I can take the court's file for a couple minutes to speak to him, and then maybe call.
We'll recall it. Has there been, let's fully educate Mr. Steyer, has there been issues?
No, he just decided he wanted to switch agencies this morning, and I'm not comfortable with that unless you approve it.
All right, so that'll be the issue.
Let me speak to him if I don't get a chance to put it.
State of Ohio versus Jade Lewis, case number CRA 23432 A and B, CRD 23433.
Yeah, Coach Runner.
Yeah. Jade Lewis is represented by Mr. Morford, and she is at Bethesda and is with QRT. She's also getting more than just anger management, is she not?
Absolutely.
Okay. So how do the state and the defendant want to proceed?
It's my understanding that she's compliant, and we want her to continue being compliant, so we're okay with a further continuance of this with a further time limit. Weeks away, Judge, and it looks like she is working on her 12-week anger management course,
has not yet completed it to get certificate of completion. So we'd like to keep on par.
Okay, and she's also been substance use.
Absolutely, Your Honor.
She had a bad screen back in the day.
Your Honor, if I may, she has really impressed me personally in her treatment.
Good job. Let's come back in a couple months then. January, because she's reporting in the QRT too. So.
Yes, Your Honor, she's compliant with QRT.
January 26th.
Let's get here at that.
January 26th will be your next hearing for preliminary hearing and pretrial.
Okay.
Thank you, Your Honor.
Thank you.
State of Ohio versus Travis L. Salyers, case number CRA 22791, CRA 22482, CRB 22420. Travis Salyers.
Mr. Morford's case, preliminary hearing.
May I approach, Your Honor?
Yes. Great report. And you're about to go to the next phase.
Yeah.
Good job.
Yeah.
This is all good. Of course, there's, anytime things change, there's a chance to slip up too, so you gotta stay more on guard on that.
Oh, yeah, for sure.
And I think you have your baby with you today? or-
Huh?
You got a baby with you today?
Yeah.
Okay.
Yeah, one of them.
How's that going?
It's going good. Lot smoother than a year ago.
Okay.
This year of treatment, it's everything happens for a reason, and I think the extra 6 months have put an impact on me.
Okay. Well, you got a lot of reasons to make this work, and it looks like right now, I think you're on the right track, so congratulations.
Thank you.
Mr. Heald.
And we are pleased with his progress as well. I'm just looking here, okay, so he pled guilty to the theft charge some time ago, and he's trying to make sure that there's nothing that needs to be done other than a continuance. I think we're okay with just continuance with a time waiver.
He's going to be transitioning to outpatient next, right?
Yeah.
Yes, Your Honor.
Okay.
No, outpatient.
Yeah, when does that start? When will you be going to outpatient?
I got like 9 days till my 180 mark again. So it should be around within the next couple of weeks.
Before Christmas?
Huh?
Before Christmas?
Hopefully.
Yeah, okay. Let's come back in January then. Do you know what your work schedule will be?
Whenever I get home, it'll be full-time. It'll be Monday through Friday.
Okay, so we'll have to be in a review hearing one of those days.
Yeah.
Friday better?
Yeah.
January 26th. So that gives you 2 months. Okay, come back.
Thank you.
Thank you, Judge.
Thank you, Your Honor.
Keep working at it. So far, so good.
Hey, Butch.
State of Ohio versus Paul Cron, case number CRA 23644 A and B, CRB 23643, CRA 22819.
Judge, this one's mine. Mr. Cron is in residential in Shawnee. I spoke with Ms. Lambert on occasion. He seems to be doing very, very well. He's approaching his 90-day mark at Shawnee. I believe he's about halfway through the program.
Yes.
Okay.
What gym do you go to?
Hi.
It says here you go to a local gym.
Yeah, we go dinner, Bethesda,
Hard Knocks?
Shawnee, yeah, Hard Knocks. Yeah, we go there and.
What's the name of it?
Hard Knocks.
Hard Knocks.
Okay.
Yeah,
Come check it out, Judge.
yeah.
What kind of classes do you take?
Hi.
You go to classes or just go there and do something on your own?
No, we all go there, and it's like one of our good behavior things, I guess.
Okay.
So Judge, we'd ask this be, your reschedule, come back close to that 90-day mark, see what Shawnee assesses for him, if anything post-inpatient, if any at all, and go from there.
Mr. Yield?
We are in agreement with that. I'm glad he's making progress. Sounds like he's feeling better about things too.
He has. He's come a really long way since we first got him, for sure.
Judge, I have his 90-day mark at about February 6th.
Okay, let's come back January 26th. January 26th will be the next hearing.
Judge, on that day, that's a district competition for mock trial, and I advise Chesapeake.
Okay, January 29th.
That works for me, thank you.
Thank you, Your Honor.
You're welcome.
Okay. Thank you, Judge.
You're welcome.
State of Ohio versus Evan Harmon, case number CRA 23457.
Judge, also mine, this one's been going on for a while. Mr. Harmon's been at OVP, has done exceedingly well this entire time. He's never had any slip-ups. Any report I've seen, he's been doing very well. He's outpatient now, correct? I briefly spoke with the state about this. I proposed an idea of dismissing and kicking this to QRT.
Mr. Yield?
We wouldn't be opposed to it, Your Honor. We defer to the court to make that.
Has he talked with the QRT? He's been assessed by them, or?
Yeah, he hasn't been formally assessed. Yeah, I've talked to her on and off because it's been going on for a while. If she's still here, we can knock out an assessment.
Is Megan still here? Ms. Dalrymple? There she is.
Go talk with her.
Have you talked with Mr. Herman about assessment?
I have not, but I can meet with him.
Okay, we'll recall after that assessment.
Thank you, Judge.
State of Ohio versus Ryan J. Plants, case number TRD 231541 A and B, CRA 19718.
May I approach, Your Honor?
Yes. good, but this is we're fairly new in this phase, right?
Yes, Your Honor.
So, good start. Want to continue to track it, Mr. Smith?
Yes, Judge, and he did have a question about the ankle monitor. He says it's been on for 4.5 weeks. I don't know if the agency feels he still needs it or where we're at on that. He would want to bring that to the court's attention.
Any predictions?
Put you on the spot.
Well, I don't know Mr. Plants all too well, but according to the report, I wouldn't object to having it removed, Your Honor.
Okay, it's been exactly 1 month. October 27th is when it was put on it, so. All right. I'll order it removed. See Mr. Major about that. I'll just say this, if you do decide to run now, you won't be welcome back in this court. I'll just send you on down to the grand jury. You'll go to the felony court.
I understand.
Okay, next hearing.
Yeah. Are we looking at a month, Judge, roughly, or?
Yes, I was
I'm
thinking the 29th of...
I could do the 29th. I was going to suggest...
December 29th?
Yes, 26th or 29th.
December 29th will be the next hearing.
I know. Thank you, Judge.
Thank you, Your Honor.
Thank you.
State of Ohio versus Mary Hampton, case number CRB 23321, CRA 23320.
Mr. Steyer's case. And she is with PRT.
Well, I believe Megan has something to say on that issue.
Okay. We'll need her in the courtroom. This is on Mary Hampton.
Your Honor, Ms. Hampton has been non-compliant with QRT. I just got off the phone with her therapist, Mrs. Brumfield at OVP. She has not been seen there since the beginning of the month, so she's not compliant with treatment as well. They're gonna send me a letter about that. At this time, QRT is gonna move forward with termination.
Okay.
She indicates that she has, and she gave me paper, she gave me a, do you have that with you? Or did you have the photograph you took of it?
I started the new job, so they transferred me to him.
She's been transferred to the Huntington office of OVP. I've got, well, are you going to Kentucky or to Huntington?
I was in Kentucky, but I got hired at Crestera in Huntington full-time, and Louisa doesn't have evening hours, so I was transferred to Huntington, but they couldn't see me till Thursday of this week in Huntington.
I asked Ms. DeMent to confirm that, and she was able to confirm that. At the beginning of this month, on November 5th or 6th, I believe, I asked Mrs. Hampton to come in and check in with me. She stated she could not do so, and I have not seen or heard from her since then.
I have a doctor's excuse here that allows her to return on the 8th of November, so on the 5th she was under work, she was under doctor's care and wasn't free to go out. I would ask that we take another shot at this. Obviously, we would have to have better, you're gonna have to report in monthly, but I think the particular day she was asked to report with this doctor's excuse dated on the 6th that she was not available to work, and we had a court hearing that day that she missed as well, so I'd asked her to bring a doctor's excuse, which she has provided. I would ask Ms. Downer, I'm going to give her one more shot at the QRT program, Your Honor.
The case here actually was nollied to QRT, so
Well, I didn't believe it had been nollied.
I've got a judgment entry. So
I don't know what we'd be here for.
if they don't want to take her back, then I guess the next step would be for the state just to take it to the grand jury, refile it.
Yes, Your Honor, we'd like to terminate at this time.
And we'll do that. And we also, she pled to the theft. I think maybe we're here on sentences.
Your Honor, if they're going to take the possession to the grand jury, I'd like to withdraw our plea on the theft and ask that it follow to the grand jury. It's the basis for the stop for the theft is the basis for the search that led to the possession charge. It all arose out of the same incident. I don't believe that they can keep one here and take the other to the grand jury.
Mr. Hill.
Or if they prefer to sentence her now, I think that cuts them off from going further, so maybe I shouldn't have said anything.
I guess we'd have to go ahead and sentence her on the theft charge, and we'd ask for a substantial jail sentence. But what we would also, I don't know whether there's any sending her back to treatment or not. I know it was a complicated set of circumstances that were described. I don't know how legitimate all those things are. We still want her to get treatment.
No, if the court allows her to withdraw the plea, and then you just nolly the theft to the grand jury, it can all be dealt with at the next level. I think that solves the problem. But of course, it is up to the court whether to allow her to withdraw the plea.
I think that, and I understand that before sentencing, I think that the criminal rules state that the court can be more liberal in having the plea withdrawn, but I think you have to have a legitimate reason for it anyway, and I think just not wanting to be sentenced is not a legitimate reason.
Well, and I'd have to go back and this is off the top of my head, but my gut feeling is if it was uncounseled, but I don't think it was.
No, I don't believe it was. Mr. Hill was insistent on a plea to go forward with keeping the case here, and now we're not keeping the case here, and yet we have this plea. So, I mean, again, I counseled her to that. If that's the court's decision, then we'll live with that. But I do think that it does. I do think it has implications on going forward with the felony that arose out of the same incident. And I would, you know, I guess we can argue sentencing. If Mr. Hill thinks there should be jail time on that, I'm going to argue that it should be treated like any other theft offense. She should be given suspended jail time and ordered to get treatment as part of her probation here.
Well, here's what I'm going to do. I'm going to, because I think it actually serves the purpose of getting her into treatment and making her be compliant, is to allow her to withdraw the misdemeanor plea, because she has a felony that was nollied, so the state can take it to the grand jury, and they can also take the theft offense to the grand jury if I allow her to withdraw her plea. If I just sentence her on the misdemeanor, and then she's non-compliant, she has a West Virginia address. She can just run back to West Virginia, and there's not a whole lot the court can do about getting her back. If the felony's reinstated and she's indicted on that, and it'll be up to that court in Ironton to decide if she's going to go to treatment as part of either before or after sentencing, whatever. But they have a lot more, there's more teeth in that, because with a felony, there's no place to run. A warrant from Ohio is good in West Virginia or wherever you go to in the United States is going to get you back to that court on the warrant. So I think that's probably the best thing to do. I believe Ms. Hampton needs treatment. I'm okay with forcing her to go to treatment even if she's non-compliant, but I don't think I have the best tools to force her to treatment in this court with just a misdemeanor. So I'm going to allow the withdrawal of the plea on 23-321, which is a theft offense. Do you want to then nolly it to the grand jury?
I believe that's our...
Okay, 23-321 is nolly to the grand jury. 23-320 has already been nollied. So...
Is it all right just
knowledge to the grand jury for non-compliance of treatment. with
It doesn't, as long as it's knowledge to the grand, actually, you don't even have to say the grand jury. You just, I know we like to track that, but all you say is knowledge, and then it's up to the state what they want to do with it. But it's an understanding it's going to be knowledge to the grand jury.
Thank you.
So the case here is over, but, ma'am, if they follow through with what they said they're going to do, they're going to take the case to the grand jury, get indicted. So the best thing you can do, I think, is to get in treatment now. And talk to Mr., you don't have to talk to him here on the record, but I think any court that looks at this is going to say you need treatment. If you come in and you're already in treatment, got good reports, you'll get a lot better results legally than if you get indicted and they have to drag you by the scruff of the neck into court. Then you're more likely to get some liberty depriving treatment, either going to STAR or going to prison or something where, you know, you don't have as many options. If you go to treatment on your own, you got more liberty. If you go to STAR, and talk to Mr. Starr about this, I think that would be probably the likely thing that would happen. You're going to be in a lockdown facility with a fence around you and no choice about what you do, except go to treatment. I would choose the other option if I had it. And then you got to get serious about this. You acted like this is kind of, as I said, like 7th grade math homework. If I want to do it, fine. If I don't want to do it, no big deal. What's going to be a big deal if you don't do this? Do you understand me? Your liberty is going to get deprived. So you got to put that first, not the other stuff. Whatever's keeping you from doing it, you got to do this. Okay? Cases here are all knowledge.
Thank you, Your Honor.
The state of Ohio recalls Jonathan Jones. Case number CRB 22686, CRA 22685, CRA 23679.
Give this to Jackie. She's gonna file. I'll get a district summary sent to her.
Jonathan Jones, he's in Holmes.
So you've had a chance to talk with him.
I have, Your Honor.
I guess it is, because it was already.
Okay, after talking with Mr. Jones, do you have anything you want to present to the court?
Yeah, I've spoken to Mr. Jones and to Mr. Nguyen. I think what's happened, we just had personality conflict that had arisen between Mr. Jones and, I don't recall her name, but one of the counselors at RRS who is not and has not been his counselor. There's just been for some reason she's having encounters with him that are causing problems. Mr. Nguyen has said that Mr. Jones wanted to stick with RRS, that he would take steps to ensure that she is not assigned to his case, so he doesn't have to work directly with her. I talked to him, I said, you know, that's about the best we can hope for if she's in the same place. You may have some encounters with her, but as long as you know she's not involved in your care, you know, maybe you can feel more comfortable with it. He said that he can live with those arrangements, so I think we can just, RRS, I mean, that discharge him or anything, he can go right back over there if the court releases him from custody, and he's willing to do so.
All right. Are you willing to take him back?
Yes.
Okay, I don't know what the nature of the things are, but let's just say this. It better be pretty serious if you want to come back in here and complain about it. It's going to be kind of like when I was a kid in school, if I got in trouble at school and I was going to complain about a teacher, I wasn't going to, unless it was really drastic, I was not going to go to my mom and say the teacher did something wrong to me, because you know what? My mom was not going to believe me. She was going to, it was kind of the opposite the way things are now. The presumption was going to be on the part of the teacher or the principal or the school administrator, not for me. So I just didn't bring it up. And I tried to make it, you know, you try to do what the school officials wanted. You know, they're in charge. You gotta comply with what they want. It's not you in charge. You understand me?
Yes, sir.
So if you want to come back here and ask for a change, you better have some really good evidence. Otherwise, no. So I don't want you running back here every little whip stitch asking for a change. Understood?
Yes, sir.
Okay, go make it work.
Thank you.
His next hearing is December 11th.
Yeah, I think we're gonna leave that on as is.
Yes.
Thank you.
State of Ohio versus Shannon Badalamenti, case number CRA 23697.
Okay, so you're Shannon Badalamenti, is that correct, ma'am? All right, Ms. Badalamenti, you have a right to remain silent. You don't have to say anything today. If you choose to make statements, though, everything we're saying is being recorded. So it can be used against you if you say something. You understand that? You have a right to have an attorney. You have a right to have one appointed to represent you if you can't afford one. You have a right to bail, and you have a right to make the state prove this charge beyond a reasonable doubt. You understand those things? The charge filed against you is possession of a fentanyl-related compound. And it's alleged in case number 23697 that on November 22nd in Union Township, you knowingly obtained, possessed, or used a controlled substance, and that controlled substance involved fentanyl-related compounds or mixtures. That's a felony of the 5th degree, maximum penalty is a year in jail, $2,500 fine. Do you understand the charge?
Yeah.
Do you have the money to hire a lawyer?
No.
Do you have a job?
No. Anyway, I do, yeah.
I didn't understand the
I do,
lawyer.
I just started, yeah.
Where?
It's in Gatlinburg, I take care of someone, grandma.
What do you do?
Like, I take care of.
Personal care?
Yeah.
Are you paid by the hour?
No, basically housing and,
You were going to live with those people?
yeah, I live with, yeah,
And is it like a private
yeah.
residence? Okay, so you don't have any money then. I'll appoint Mr. Morford to represent you. Are you, I have a County Road 1 South Point address, is that correct? Is that where you've been living?
Yeah, it is, I just go there during the day,
Are you an Ohio resident?
yes,
Do you have Ohio Medicaid?
yes. I go to the methadone like every day too, just so you know.
You have to do what now?
I go to the methadone clinic
Oh,
every day.
in Huntington or Ashland? How many milligrams a day?
200.
Wow. That's one of the most I've ever heard of. How long have you been going there? What's the state's position on bond?
Well, in reading, Your Honor, the affidavit, at the time of the arrest, she denied the fentanyl in her possession belonged to her. So I don't know if she still holds that contention or not, but given the fact that she's on methadone, that raises some concerns right there. It sounds like she's attempting to do something to curb her addiction, but it's about the worst way to do it other than using. So we would suggest either a $10,000 cash or surety bond, or if she wanted to go to treatment, be assessed for treatment, we'd be okay with an OR bond once she's accepted into a program.
And she's going to have to go somewhere where they can handle methadone. It's probably OVP or...
We have a female vet available if she's willing, Your Honor.
She want to take a urine screen today? Okay, let's have her do a urine screen. Then I'll decide the bond after she does the urine screen.
State of Ohio versus William Price, case number CRA 23703, CRB 23704.
Sir, you William R. Price. Mr. Price, you have a right to remain silent. You don't have to say anything. If you make statements, it's all being recorded. It can be used against you if you admit something about your case. You have a right to have an attorney, have one appointed if you can't afford one, have bond, and to make the state prove these charges against you beyond a reasonable doubt. Do you understand those things? You were just handed copies of the charges. Case 703 is disrupting public services. It alleges November 22nd, Perry Township, you purposely damaged, tampered, impaired some sort of communication device. Usually that means telephone. That's a felony 4, maximum penalty is 18 months in jail, $5,000 fine. Case number 704 is domestic violence. It alleges November 22nd, Perry Township, you knowingly caused Jacqueline Mershon to believe you would cause physical harm to her, or that you actually did knowingly cause physical harm to her. That's a first-degree misdemeanor, domestic violence. Maximum penalty is 6 months in jail, $1,000 fine. So those are the two charges. Do you understand them?
Yes.
Do you have the main household? Do you have a job? No income? Social Security? That's your only income? Okay. Mr. Stratton, we're back to you.
Yes.
We batted through the lineup and we're back to you. M1 domestic and a probably something with a phone. Usually that's what those are. Disrupting public utility, something like that.
It was a cell phone.
Yeah. State's position on bond.
Well, the allegations, Your Honor, if they are to be given any weight, would indicate that maybe Mr. Michon has some issues that need to be dealt with. It's alleged that he was talking about suicide, and there was also mixed in there the domestic violence and the depriving Ms. Michon of her phone. We'd like to see him assessed and perhaps get into some sort of a program. I don't know whether there are substance abuse issues or mental health. But that would be a way for him to not, in our estimation, need to be in jail, but we want to keep an eye on him and make sure that he's getting care if he's going to be out of jail.
Your Honor, I'll let him, I've already told him no help. I'm already wanting to go there. They told me she's going to have to call and set up an appointment.
Have you been there before?
No.
Do you have any information from Ms. Mershon if she wants a protection order or anything?
We have one prepared. We're going to ask for one. We haven't heard from her yet, but we intend to. You know, Shawnee, I don't think they have a residential program, and I don't know whether that's needed at this point or not, but I also know that there are other programs that I think we have better luck with getting reports from.
Agreed.
Your Honor, you'll go anywhere you want them to go to get assessed and treatment.
Well, what I'd like to get some more information from her. One, does she want a protection, or what's her feelings on his housing? It doesn't mention whether substance use is an issue. I'd like to know that. If there's a history of substance use. Yeah, again, I think that's most of what I need to know. History of treatment, if she has any information on that.
Your Honor, it doesn't speak to the substance abuse issue, it is a mental health issue, so.
Okay, I'd like to get her input on it. Does he have other family? I don't know if she's family.
It's my daughter, he's staying at his house.
Okay, so he would have, and that's not with Ms. Rashawn. Okay, I'm gonna let the prosecutor call them, and I have him back out, and we'll finalize things. If you wanna go back and talk to him, you know, if the court's file to do that, then we'll finalize bond arrangements after that.
State of Ohio recalls Evan Harmon, case number CRA 23457. Evan Harmon.
Okay, Mr. Harmon was being evaluated for QRT.
Yes, Your Honor, he's signed all terms and conditions.
So Judge, in light of that, we ask for this to be nollied in light of its acceptance of QRT.
Deal?
Yes.
You're in agreement?
As long as everybody else is, then we're fine with it.
It's a possession of cocaine, felony 5, arose on July 7th. He's got a certificate of completion from OBP for the residential program, and he's doing outpatient now, is my understanding.
That's correct, Judge.
Okay, so it's going to be nollied to QRT.
Thank you, Your Honor.
There's no misdemeanors to stay here, so.
Awesome. Thank you, Judge.
Thank you.
State of Ohio recalls Tory Lindsay, case number CRB 23642, A and B.
All right, this is Mr. Scott's case. There had been a plea there, we were talking about sentencing and treatment options.
That's correct, Judge, and I believe they did work it out where she could do outpatient. Looks like she'll be reporting soon on that. Tomorrow morning. So as early as tomorrow morning, Judge.
That's good, that's fast. Now, I want to keep it on a short track, because if this doesn't work, then you're going to have to go inpatient.
Yes, Your Honor.
Agreed?
Yes, sir.
Because it's too dangerous for you not to.
Yeah.
I discussed it all with her.
Yeah, I understand.
Okay, I'd like to come back in the 2-week range. What's your schedule, Mr. Scott?
That's a good question, Judge. I do the first, but that's going to be too soon.
Looking more like the 11th, 8th, 15th, somewhere around there.
I have the 22nd as soon as I'm completely free on a Monday or a Friday.
Well, you don't have to be completely free. We could even set it.
Well, Judge, if you're willing, I have a 10 a.m. on the 15th in Lawrence County. I can come here directly after that. Common Pleas Juvenile.
Okay.
I can come directly after that. We can
That'd
push
be
this
fine.
later
I
in the
mean,
docket.
look, it's 1 o'clock, we're still here. In fact, I'll even set it, let's just do it at noon.
Perfect.
December, did you say 15th?
December 15th, Judge.
December 15th, noon, for pretrial and report from hometown.
Now, did she plead today to the charge?
Well, I think that's what we started. It sounds like Judge wants her to see how she's doing in outpatient and then adjust sentencing off that report.
Yeah, so actually, let's put it down for sentencing. She did enter a plea today. Delay sentencing until December 15th. If you want to stay outpatient, you got to do good.
Yes, Your Honor.
Clean screens, do what you're supposed to do, get a good report on December 15th. Otherwise, you're gonna go inside.
Gotcha.
It's too risky
Judge
not
Member,
to.
she also agreed to come to work with me as well.
Okay, we'll put you down for Thrive, work with Thrive. So that's an additional coach that can help you on the outside. You got some, you know, when you're not there at hometown and you got some issues, call them and they can talk you through it.
Yes, sir.
Okay?
Thank you, Your Honor.
There you go.
You want to get it in?
All right, thank you.
State of Ohio recalls Stephanie Plummer, case number CRB 22-584. Stephanie Plummer.
Okay, Stephanie Plumley had called this morning and said she was delayed. She would try to get here, but she still is not here. It's 1 o'clock basically now. So she's got 7 days to get here before a warrant will issue.
State of Ohio versus Brandy M. Hines, case number TRC 23-182, TRC 22-2783, A and B.
Mr. Morford's case, sentencing, she's at Ohio. Yes. Yes.
From TCC. This time, takes you back and takes.
Okay.
No, my living situation wasn't good for my sobriety, so me and my cousin Mahajan decided inpatient was my best friend. Yes, I didn't relapse. I'm still sober.
And you'd been at the counseling center before.
Yes, me and my counselor at Mahajan decided my living situation wasn't good for my sobriety, so I decided to go back in inpatient with my children.
Okay, your kids could go with you there.
Yes.
All right, and that's what they call a stepping stone.
Yes.
Well, sounds like a good decision, so let's have you continue there, and I'll just delay your sentencing more. We'll see how you do.
Okay, thank you.
January 5th, Mr. Morton?
I'm good then, Judge.
January 5th.
Or you just want to recall it? Try to call it a work.
Thank you.
Why don't you just call one Huntington and see if it's it? You want to do that, or you just want to recall?
State of Ohio versus Jeremy A. McMillan, case number TRC 22-769, A, B, and C, TRC 20-2014, A, B, and C, TRC 19-2341, A, B, and C.
Oh, see.
Yes.
Jeremy McMillan.
I think he had a medical procedure, dental procedure.
Yes, he had oral surgery this morning, Your Honor.
Okay.
Miss Kim Gannon took him, actually.
Was concerned about, like, he's not here, and I forgot he was going to Columbus, but, so
Yes.
everything's still going well.
Yes, he's a really good client, Your Honor.
Okay, good. It's getting worried.
I was too.
Let's schedule him for, I think, December 29th, you're here?
I'm January 29th, I'm here. December, that week after Christmas, I'm not here.
Okay.
But I'm here January
Since you wasn't here today, I don't want to go 2 months. Let's
Sure.
make it January 5th. When are you available? in
I think
January?
that'll, yeah, I know I'm available. We set a trial, yes, I'm available that day.
January 5th.
I can do that.
Will be his next one.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Scott Taylor, case number TRC 222629. Approach, Your Honor.
Yes. It's Mr. Smith's case. Okay, it's a good report, good training. Try to get you through the holidays, and then maybe we can conclude this.
That would be great, Judge, if we could.
January 5th?
I'm here then, yes. January 5th, 10 o'clock.
Okay, good job.
Thank you. Thank you, Judge.
Was that yours?
Yes, somebody stole. You can't trust me. Somebody stole our pen off the chain.
State of Ohio versus Sierra Helms, case number CRB 23418, CRD 222711. Sierra Helms.
Roger.
Did not check in, Your Honor.
I don't know if we, since you didn't have to be here, there's no further problems. This was an M4 trespass.
But there was supposed to be costs paid.
And I can't remember.
No, I didn't say that. Just says 90 days, no appearance required.
That's, not that there's no cost.
And no costs actually were going to be requested. I don't remember why, but.
Well, she went to her ex's house, and her friend, their ex's friend let her in, so I don't know if the state could prove it, but we agreed to be no cost and just stay away.
We did.
Okay, I guess I'll just, there was also a traffic matter. I'll go ahead and dismiss it too.
Okay, I kind of inherited that one after I got this, and I wasn't really sure what was going on.
So that's 222711 and 23418.
I'll let her know, Judge.
Your Honor, for the record, we did make several attempts to reach the alleged victim, and his phone was not, we weren't able to reach him by telephone. It said the number is unavailable.
Yeah, we did it this way instead of setting it for trial and then taking up the court's time, and he wasn't going to show anyway. Thank you, Judge.
You're welcome.
State of Ohio versus Alec R. Berry, case number TRC 23957 A and B, TRD 23292 A and B. Alec Berry. He's here.
That's what I'm saying. So when do you hear back from them? You? Yeah. Next week.
All right.
Okay, we ready to go ahead and finalize this at this point then?
We can, Your Honor. Yeah.
There was a plea to the OVI, and he already pled to, there was a prior case that was for leaving the scene. He did make a payment November 6th. First offense with a refusal.
Your Honor, he has done very well in treatment, and I think they attest to that. So I asked that you treat this as just a standard first. I don't think there'll be any objection from the state on that. And we would recommend that you give him minimums on the case.
Okay. And where you say you're going to work for union, or where's that?
Millwrights.
And when's that start?
My cousin is looking into getting me into there sometime whenever I'm done with this treatment.
Okay, so you don't, it's
Or
not,
maybe even while, I've been talking to my counselor about starting while I'm in treatment. It's just a job that you have to travel and stuff a lot.
you probably have to, do you have to test and be clean?
Mm-hmm.
Okay. Well, that's good. That sounds like a good job. State, what's the state's position on that?
Well, we're not opposed to the court going ahead and pronouncing the sentence today. It is a first offense. He's apparently done very well in treatment, so we don't oppose the minimums that are required. And as far as the 3-day driving school, the treatment probably should stand in lieu of that.
Okay. You have a right to say something if you want, Mr. Berry, or your counsel. Do you have anything you want to say?
Nothing further, Your Honor. Do you have anything?
No, Your Honor.
Okay, I'll impose a $500 fine, so I'm giving you a $500 break, because normally on a refusal, I impose a $1,000 fine. So I'm giving you a break because you've done well in treatment. Order you to pay the court costs. License suspension will be for 6 months. And so that's going to be up fairly soon. 20-day jail sentence, which I'll suspend. I'll order you to do 5 days of community service, 2 years of level 4 probation. I'm going to order that your treatment's in lieu of going to the driver intervention program, but I want you to finish it. So I want you to keep going until they say you're completed. Looks like you're on track to do that. And then you've got this other case. You got to finish both of these. You got some community service you still owe on the leaving the scene case, and now you got community service on this one. So I want you to get out here, get busy, and get that done.
Your Honor, I should be done with the community service from
the prior case.
Yeah.
Okay. Well,
I think not
all
all
hasn't been updated since August 31st. So.
Okay.
So if you've done something since then, it's not in the file yet. I'll set they'll do it for the next review hearing. I'll set your next review hearings, or they should do it for the next review hearing. I'll set them for January 19th.
You're under the Miscellaneous violation, is the B case.
$20 fine.
I'm sorry, what was that review hearing again?
January 19th.
Thank you.
The review date. Okay. So just go over there to
And they see Mr. Major.
Mr. Major with probation. Okay.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Kara Hearn, case number CRB 2351.
So
this is Mr. Stratton's case, and it's set today for sentencing.
So, Your Honor, Ms. Hearn, Mrs. Hearn, had a relapse. She recognizes that. When she was on her pass, I understand that Bethesda is recommending that they restart services, and that QRT, I'm not sure what QRT has decided. She is between keeping her on QRT and not. I'm not sure what.
I think it's going to be up to Mrs. Hearn. When I spoke with her, I told her that when a relapse occurs, it's very important to be open and honest about that, and especially with treatment and your therapist and all that stuff. And she's not willing to quite admit the relapse. It came to my attention this morning from Kristen that she's also tested positive for Suboxone when she is on the Sublocade shot. That came up on the lab confirmation as well.
That's correct, Your Honor.
So that came off the street.
I had a lapse in better judgment.
So, Your Honor, she's been doing good for a while, and then for a while. And we always know these are a couple steps forward and one step back at times. So I just ask that you allow her to continue in Bethesda. And I know there was some discussion of an ankle monitor. I'll leave that up to the court, whether he, because there was some discussion I hear of her wanting to leave treatment. But she has indicated that she has no intentions of leaving treatment to me. And she has never just up and left treatment since we've been doing this, Your Honor. So I don't think she's a flight risk. I know there might have been some statements made, but I've never known her, like we've had other people who just got up and just left. She's never done that.
And she has a child here in the county too, so I think that's another guarantee that she's going to be around. I mean, she might leave, but I can't see her leaving permanently.
Not going anywhere.
Her child being here.
Yeah. So I just ask that we set this maybe even relatively soon, sometime in the middle of December, or maybe a little later, but.
Mr. Hill, do you have a position on this?
Well, we want her to continue in treatment if they'll have her, and hopefully she can get back on track.
Your Honor, I'm willing to give her another opportunity, but she is going to have to get honest about what happened, and if she agrees to stay in treatment on a program restart.
Yes, yeah, definitely. She's remorseful for what's going on, and she's going to restart the program and take it from there.
Is that correct, Ms. Hearn?
That's correct. I was wondering if I could change programs, though.
I don't think that's a good idea.
Okay.
They've been good to you there, and you've had times where you've done really well.
I know.
I think they know your whole history and care about you. That's my sense, that everybody there is really rooting for you to do well.
They are.
So I don't think going to another place is a good
6
answer.
months is a long time.
Yeah, it is.
I've already been there almost 6 months.
Yeah.
There's other programs that aren't quite as long.
She just misses her family, Your Honor.
I understand, but didn't this happen when she got passed? So
It did, Your Honor.
It did.
Is that part of the issue?
Yes.
Okay, well, I think you need to stay where you are. You're in the right place. We might need to make some other changes, but I don't know that I can suggest that. Let's come back let's come back the day after Christmas.
26th, yes.
The 26th.
26.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Destiny Gerald, case number CRB 23595. Destiny Gerald. Mr. Steiner's case.
This was set for sentencing today. Destiny Gerald. She hasn't appeared.
Does not appear to have appeared.
All right, there'll be a warrant issued for failure to appear.
Thank you.
Does she have a bond up?
I think maybe she does. I think you're right. Let's see. She does have a bond up. She's from Burnsville, West Virginia, which I have no idea where that is. You know where that is, Mr. Stoddard?
I think it's near Glenville State College.
Okay.
There's a very good fishing lake, bass fishing lake there in Burnsville.
Yes. Okay.
Yeah, if somebody could ask me, it's all right.
I'm going to send a copy of her bond to Mr. Sowers.
Thank you.
You're welcome. So the warrant will issue today, your warrant issued today. You set bond forfeiture hearing for December 18th. This goes in her file.
State of Ohio versus William Price, case number CRA 23703, CRB 23704. I can hold it.
William Price is Mr. Stratton's case, and, we were going to decide on bond after.
Yes, I spoke to him, Your Honor. There is no substance abuse issues here, there's mostly mental health issues. This occurred at his daughter's, this incident, and that's where he will be staying.
Is this Jacqueline Rashawn, his daughter? Or?
No, that's his girlfriend, fiance.
Were you able to get a hold of anyone?
The number that we had for Ms. Rashawn was not a working number. However, we learned that where she's employed, and Jasmine is trying to contact her now.
So they just recently got new cell phones. Mr. Price doesn't call his own number at the moment, so he doesn't know about her.
It's another change from when my mom wouldn't go complain to mom about getting in trouble in school. I also had about 15 phone numbers that I had memorized. All my friends, I knew all their phone numbers, their neighbors. Nobody knows a phone number now.
We've got lots more information now.
Okay.
She's writing notes, finishing up. Hurry. You're like a typewriter. Okay, this is Jacqueline. Chapter 1.
Sounds like she had a few things to say.
Attempted to contact victim. Okay, so the Verizon number was works at St. Mary's Huntington. Defendant took phone to jail that is in her name. Will he give it back? Victim wants protection order. Defendant is not currently going to counseling. She's afraid that his mental health and the potential for him to commit suicide. She doesn't want that to happen. There's no substance abuse issues. She says that his daughter is allowing her to stay there. Daughter is afraid of her dad, doesn't want him to come back. So apparently he's got a place to go, but not with his daughter. But
yeah, I think he said he was going with his daughter, right?
Well,
wants her to stay there and
yeah.
That's the one I directed when I went to jail. I could give her the cell phone back.
But more importantly, at this point, I mean, that's important, but I guess neither one of the ladies want him around right now until he gets help. And
He's
then
fine with it, Your Honor. He didn't realize there was a dollar amount in the same way. The issue wasn't with this dollar. That's where generally they were.
Apparently, this Jacqueline is living with her.
yes,
And Your Honor, they were able to get a hold of Jacqueline because Mr. Price told me that she was working at St. Mary's. So he said it was.
Does he have a place to stay other than with his daughter?
He does. Get my clothes and stuff in her house.
Well, you can have somebody else do it. I don't want you to go do it.
But I can call, like I said, if I need the cell phone, I can have him take it to me.
Who's him?
Jim Hall.
Who's that?
That's a friend of mine, lives in Kentucky,
Where would you go stay if you're,
at his house.
okay, and you're sure he'll let you do that? Mr. Hill?
well, you know, this is really about Mr. Price's well-being, and
I ain't gonna do anything, I mean, I just blew up that day, I just had a bad day.
you have to have a really bad day to
Well, it's been
threatening
building.
to kill yourself and having a knife and scaring people to
It's
death.
been building. We come up here to visit our kids, her car blew up, and then we bought a truck, and it's just, everything was ready to go. Something go wrong with the truck, and we got stuck here, and it all started, I was trying to figure the truck out, and she come out here yelling at me, I wasn't doing enough, and then it all just, I didn't hurt you.
Well, we don't want you to hurt yourself.
I'm not on it. I'm not afraid of it, right? It was just too much stress, I wouldn't hurt myself.
Your Honor, I don't have any indication that he would want to hurt himself, except what's in the report. He didn't seem, when I was speaking to him in the back, he seemed pretty level-headed, interested in getting this case resolved some way in the future. He doesn't appear to be suicidal to me.
I just want to try to do it.
I don't know who would be able to assess him anyway. I mean, today.
Your Honor, we always have, typically we have mental health issues or issues with suicide connected with substance abuse, but that's not the case here. And if you allow him, he's got an appointment, he's already spoken to Shawnee Mental Health, to allow him to actually speak to them more.
Well, I used to be on the board of directors. So the problem is you can never get them, they're not very cooperative about informing the court as to what's going on. It's like pulling teeth trying to get a report out of them. That's been my experience.
Seems like maybe Path would be a better path.
The only thing is, he's located in Ironton or Kentucky, right? So, do you have a medical card?
For Virginia.
For Virginia.
We were staying, that's what I'm saying, we were living in Virginia, coming back to see the kids, her car broke down, and we bought a truck to go back, and it's just been one thing after another, every time we get the truck fixed, I think we're leaving, we need something else to go wrong with it, and it's just, the stress between the two of us caused us to fight. But what, and I just had a bad day. I don't want to kill myself, I want to live to see my good grandbaby on the way.
Okay, I'll let him out on a $2,000 OR bond. I'm ordering you to stay away from Jacqueline and whoever she's around, which apparently is your daughter too. She's living with your daughter. You can't go there either.
We've got a protection order for him to
So we
sign.
probably need to come back pretty quick to try to get some resolution on this. So I'm thinking either this Friday or next Monday.
Well, we tried this Friday, I'm not so sure if it'll be good, any sort of treatment on this Friday.
Well, let's do it next Monday, because Friday's pretty terrible. Are you here Monday, the 4th?
What day you want?
December 4th?
Yeah.
December 4th. He can sign a, did I say 2,000 OR bond?
Yes, Your Honor.
Okay. Is Pat Omenta they given a screen yet, or?
Well, I was back there, she had. She said municipal court charges as well.
Oh, okay. Well, we may need to let her, who did I appoint to represent Ms. Pat? Was it you or Ms. Patalemente?
No, it's a formal.
Okay, it's easy. Yeah. Hopefully it didn't take off. It's happened before. Just go ahead and do it. Since they gotta get signed municipal.
State of Ohio versus Shannon Badalamente, case number CRA 23697.
Oh, she's in there now, okay. Well, let's wait. She's trying to give a screen now. So let's go ahead with Mr. Holt's case.
Okay. State of Ohio versus Andrew J. Farley, case number CRB 23667, CRA 23672, CRA 23674.
Is he gonna do that?
Well, he's in custody too, so.
Yeah.
This is Mr. Holt's case. I'd set it for trial today at noon. 1:30 now.
Your Honor, he has a holder from somewhere else.
Meigs County, Common Police Court.
He's getting arraigned in common police on Wednesday.
So
In our Common Police.
we proposed that if he pled guilty today, that we would agree to a sentence that would be concurrent with whatever else he's going to face, and let him go on to the next location, his next court. Pardon?
He's been in jail for about 3 weeks.
Give him credit for that. And Ms. Simmons is here. She's the victim in this, and she understands it and agrees with it.
He also he's got a felony here too.
It's not already.
It's already been on, yeah, it was.
Yeah, it went to the grand jury.
And there's got the extradition, signing common police.
And he's got this Meigs County, which is a felony too, it says.
Which we're fine with that, but hold it for common police. So, I mean, I guess we would waive the rule 4 here and let common police go with it.
Really?
Well, I mean, they have to, I guess.
They always send it here.
Yeah, I
don't know why they can't deal with it.
But as far as these pending charges, we would be okay with, if he pled guilty, to recommending a sentence that would include the time he's spent already and then suspending any further that, or maybe, credit for time served. Our main concern here was the convictions.
Okay. So Simmons, do you want to be heard or have anything you want to tell me about this? Or?
I'm good with that. He's got other things to do.
Sounds like he's going to be tied up for a while.
11/6.
Okay. He's been in since November 6th.
Yes, sir. Our recommendation would be to
3 weeks.
leave him to, sentence him to the town he served, and then he's going to have, I don't know what it would be for probation, so I would like to try to as well.
Yeah. Anything you want to tell me, Mr. Furley?
I apologize for my smart mouth last time, and I'm sorry, Cheryl. I apologize. I fucked up. I apologize. I'm sorry. I'm sorry. I'm guilty. I ain't nothing else I can say.
All right. On the, this is 23667. 667, assault. Do you want an order for him to stay away?
I mean, he's gonna be gone for a while, so.
It's up to you.
No, I.
Okay. 667, you're on the long case.
667?
Yeah.
Got that one up.
Okay, let's do that. $200 fine, court costs, 60 days in jail, suspend 39, credit for 21 serves.
No, she doesn't.
2 years of level 5 probation, which is non-reporting. I will not set a review hearing now. And then, does he want to waive this Rule 4 hearing? Okay. Was the 673, was it knowledge to the grand jury? Because it arose the same time these felony charges did that were
What was the case number?
673. Yeah, it was a menacing. It was the same day.
I don't have anything for that.
There was 2 possession charges with it the same day. They got knowledge to the grand jury. I didn't know if you can just dismiss the menacing.
Yes, we'll do that.
It'll be knowledge. 673 is knowledge. So, you can't postpone. I'm setting at 10,000. Had to be posted today. I'm going to put on here, he will be returned to Meigs County upon Common Pleas Court of Lawrence County lifting their holder.
What are you doing with that, Mr. I'm sorry.
We'll ship it down to Common Pleas and let them deal with it.
Okay.
See if they punt it back to me.
He does have a holder.
Yeah.
Correct. So I'll give him
From
a
Meigs
copy
County.
of the holder.
I would just send this down with the other stuff and then see what they do with it. Okay, I think that takes care of Mr. Furry.
Thank you, Your Honor. State of Ohio recalls Sharon Badalamento.
We need Mr. Morford. He's here.
He wasn't back in.
Here he comes, Your Honor.
Oh. Well, I don't want to interrupt her. She's in the middle of giving a sample. So just wait patiently. She has, I'm told she has charges in higher municipal.
I'm not familiar with that.
I think a warrant. printing or not. So I guess we're waiting on the results now.
She dipped it in toilet,
Okay.
so it's not registering anything, and it's,
Cold.
yes.
All right, well, that's a fail.
Definitely did not dip it. Man, the whole cup's wet from where, and it's crystal clear, and there's not much in it, so there's no temperature.
I've been there since Wednesday, like it wouldn't even be anything in crisis or anywhere, but I didn't dip it. I eat all I could, because I haven't been eating and stuff.
All right, I'm gonna set bond for her at 2,000 cash or surety. Set the next, and when did she come into the jail? On 22nd? Okay, we gotta do the preliminary Friday first. December 1st is your next hearing. 2,000 cash or surety. That's it. Court's adjourned.
You have a good Thanksgiving? Oh, yeah. Got it.